All right. Hear ye, Court of Appeals State of Michigan is now in session. The Honorable Philip P. Mariani, the Honorable Christopher N. Travilcock, and presiding, the Honorable Michael F. Bigola. All persons having business herein, draw near, give attention, and they shall be heard. God save the United States, the state of Michigan, and this honorable court. May be seated.
Mr. Granzato, a little late to take his feet, but he made it there. Good job. Good morning. On behalf of my colleagues, Judge Travilcock and Judge Boonstra, who's here via Zoom for our first item of the day, welcome to the Michigan Court of Appeals. This is panel 2 in Detroit. Day 1 of our case call. I'll give you my usual advice, admonitions. We've read your briefs. We've read reports from our staff on all the cases we'll be hearing today. You don't need to belabor the facts. Just cut right to the salient legal issues and let us know as succinctly as possible why you think you should prevail in your appeal. In cases involving minor children, I'm not sure whether we have any of those today, but initials only, no proper names. These proceedings are being recorded and will be uploaded to YouTube within the next 24 hours. So initials only when it comes to minor children or other protected individuals. Judge Mariani, who is the third member of our panel, is recused from the first item we'll be hearing today, which is why Judge Boonstra is joining us for this first item. After we hear this case, we will adjourn very briefly and then resume the bench with Judge Mariani to move back to item 1 on today's case call. So with that, we're going to start with item number 10, consolidated cases, docket numbers 368752 and 372858, estate of John Edward Rogers versus McLaren Macomb.
Good morning. I'm Mark Granzato on behalf of the plaintiff appellant in one of these two cases and the plaintiff appellate in the other. This involves the Pandemic Healthcare Immunity Act. Over the last 15 months, this court has issued 3 published decisions and 4 unpublished decisions addressing this immunity provision. I have to tell you this at the outset as a prelude to what I'm going to be talking about. The first of the published opinions that this court issued begins with one sentence, and it says, Plaintiff Warren Franklin appeals as of right an order granting defendant's motion for summary disposition. The plaintiff in that case was Warren Franklin. I don't know why, but every single case that has talked about this since from this court seems to think he was Franklin Warren because it's always referred to as the Warren case. The Supreme Court, by the way, did not say that in their order denying leave. I assume that the correct name is in fact Franklin in light of the first sentence of the opinion. So that's what I will be using today. If you hear the word Franklin, you can think Warren if you like, but it's Mr. Franklin.
Thanks for advising us.
In the 7 cases that this court has had on this immunity provision, there's an obvious recognition that this immunity is not absolute. There has to be something in the relationship between the acts involved or the malpractice alleged or the injury and COVID. There has to be some relationship. In fact, it was what the Skinner-Baines case referred to as connection. And you don't have to do this because I did. This court's analysis of what that connection is has not been consistent. There have been various opinions as to what that connection must involve. But I do believe that in the most recent published decision from this court, issued 3 months ago, the court finally got it right. The case is Jokinen, and the key connection from the Jokin case is the following. And by the way, I think this is the only defensible way to read a statute that is pretty hard maybe to piece together, despite the fact that it's relatively short. And what the Jokin court said is the immunity conferred by the PHCIA just applies to injuries sustained by reason of services provided by a healthcare provider or facility in support of the state's response to COVID-19 pandemic. In other words, the connection has to be between a COVID-provided, COVID-related service, medical service, and the injury.
So in this case, would it have been enough if the nursing assistant, instead of being drawn away to grab a towel, if she would have been called away to resuscitate a COVID patient?
You are absolutely correct. That is absolutely the correct way to read this statute. And by the way, they don't have those facts, but you are completely correct in saying that, because
You can
that
keep saying
would
that
be,
if you'd like.
pardon me?
I said you can keep saying that if you'd like.
Okay, great.
He doesn't hear it very often.
Right.
No, but the point is, that would be a situation in which a COVID-related medical service is in fact related to the injury. Okay, because she was called away and Mr. Rogers fell off the chair or got up and fell, whatever happened. But the fact is, that would be true. Now, they do not have those facts. The defendant has tried to suggest that maybe the nurse in this case, Ms. Murray, I presume that's the pronunciation of her name, Ms. Murray got called away, okay, to in fact tend to a COVID patient. But Ms. Murray, and by the way, the testimony with respect to Ms. Murray and Ms. Selva is irreconcilable. I hope you understand that. Ms. Murray said she told Ms. Selva, don't let him go into the shower. Okay, don't let him take a shower. He's not capable of doing it. She was mostly worried about, and this is important, especially in the connection that the Jokin court talked about. She was mostly concerned, Ms. Murray, with her own safety. But what Ms. Murray said, ultimately, okay, because if Ms. Murray had testified that she was going to assist Mr. Rogers, as you said, and she was going to be there with the nursing assistant, and she was going to be there when the nursing assistant left the room, the shower room, okay, and she was called away for an emergency COVID patient, that would fit under the statute. But Ms. Murray testified, and this is her quote, I was not going to sit in there with him because it just wasn't going to happen. That's what she said, because she was afraid of showering in a unit. Remember, Mr. Rogers did not get diagnosed with COVID. He was in fact negative for COVID when he was tested in a hospital. He didn't have it, but she thought, based on her description, she thought that just being in a shower room with vapor in a ward that contained COVID patients would be detrimental to her and her children, and she didn't want to bring it home. So she did not say, I would have gone in there with him.
At what point do the facts become an issue for the jury to decide versus us as a matter of law?
That's a very good question, because ultimately, another good question. Ultimately,
I better stop while I'm ahead, huh?
No, this really is, when you look at it, and it's been described in a couple of cases, it's a causation question. It really is a causation question. What is the relationship? What is the connection between the medical service being provided, COVID-related medical service, and the plaintiff's injury? That really is a causation question. Okay, and if somebody had testified similar to your hypothetical, that I had to leave the room to tend to a COVID patient, that might be a causation question that might go to the jury. Now, we don't have that causation question precisely because That's not what Ms. Murray testified to. She said she was never going to go in there. She was never going to assist somebody in a COVID ward. Okay, so what we have then, okay, is the Joking case, which gets the relationship right. And the other thing about the Joking case is the plaintiff did not have COVID. He had tested negative for COVID. And obviously that's similar to what we have here. So the bottom line in this case, post-Joking, is was the treatment, the medical services being provided COVID related, and was that related to the injury? And the fact is, the services were not provided. That's another issue that we've raised in this case, kind of an interesting question involving whether you have to have active negligence or you could actually have an omission. But put that aside, because the more important question is obviously whether the statute applies. But the fact is that the medical services being provided is a shower. Okay, and it had nothing to do with COVID. And the case is really as simple as that.
Wasn't there some suggestion that the patient wanted to take a shower because he didn't want to take COVID home to his family?
This is a disputed point, you understand, in the case, because what the plaintiff's family, I think it was his spouse, it might have been someone beyond the spouse, testified to is that he had tried to get the nurse's attention sometime before to use the bathroom, ended up soiling himself. I like that term. In fact, he said he needed a shower before he went home because of that. So there is a dispute, but even so, the connection is not between what he's doing and the pandemic. That's not what Joking calls for. The connection is fundamentally different.
Would it make a difference if at the time the COVID guidelines were to shower, or if a doctor had directed him to shower before going home? Because you're on a COVID ward and the doctor said shower. If a doctor or a nurse had directed him to shower because of COVID, would that make a difference?
Well, I don't think it's medical treatment. I mean, you have to have COVID-related healthcare services.
But the shower, you just said the shower was a service. So if the doctor directed you to shower, that's a service because of COVID, would that be enough?
Well, you may be right for the third time. But the fact is, these are not our facts in the case. There's nothing like that.
Now you're arguing against yourself.
If you'd like me to sit down, I certainly will. I don't enjoy hearing myself talk anymore, but I will sit down.
I think we get it. Thank you.
All right, good morning. May it please the court. David O'Cute on behalf of McLaren McComb, the defendant appellee in this case, the defendant appellant in the other.
You have a cross appeal, right?
Correct,
Okay,
correct, on the
so
gross negligence
The
claim.
way I like to handle these, argue in the first case as appellee, then argue your cross appeal. Mr. Granzato has rebuttal on his appeal. He'll get his rebuttal time and then he can respond to your cross appeal. And then you can have rebuttal if you want it on your cross.
Sure,
Okay.
yeah, that works for me.
All right.
So I think what we're doing here is based on Mr. Granzato's arguments that he's laid out, we're essentially narrowing the statute beyond what the legislature intended it to be, which is not what the Warren opinion says, this court in Warren. I'll call it Warren. That's what it is in my brain is Warren, so I'll call it Warren. There's really there were undefined terms in the statute that this court defined in both Warren and then subsequently in Skipper Baines. Because the in support of language, we were unclear of what that meant. Mr. Granzato didn't really talk about that much, so I'll touch on that in just a second. But the by reason of language is, I think, what Mr. Granzato was focusing on in his argument. And that was defined in Skipper Baines by this court as the some connection requirement. So starting first with in support of, what does that mean? Any healthcare services that assisted, helped, or promoted the state's reactions and actions taken as a result of the COVID-19 pandemic. I think indisputably in April of 2020, when Mr. Rogers was at McLaren McComb, the hospital was in fact providing healthcare services in response, in support of the state's response to the pandemic. They were open. They were accepting COVID patients. They were accepting patients who were suspected of having COVID, like Mr. Rogers. They had an entire unit dedicated to the treatment of COVID patients and patients who were suspected of having COVID. That's the unit that Mr. Rogers was on, which aptly enough was called the COVID floor. That's where he was admitted to because he presented with signs that were suspicious for COVID. Now, Mr. Granzato focused on the lack of a COVID positive test. He tested negative for COVID. A couple problems with that. First is that at that point in time, in April of 2020, we're a little bit less than a month into the pandemic. COVID testing was in its infancy. There were several false negatives at that time. And so this court shouldn't put too much weight into the positive versus negative test because there were several false negatives. In this case, Nurse Murray testified that the COVID patient that she was transferring to the ICU at the time that Mr. Rogers fell was initially tested negative for COVID, which was a false negative because he shortly after tested positive for COVID.
So just so I understand the distinction, if he had been admitted, let's say he had fallen at home and broken his ankle and he's in the ER and I don't know, he gets up and then falls because he was in the ER and it was during COVID, does that fall under the act? Or is it because he was admitted with COVID, potential COVID symptoms, assigned to a COVID floor and was being treated generally in COVID and in response to COVID? Is that your position?
So yes. So in that first situation, I think it's a lot more attenuated where it's completely unrelated to COVID. In this case, he presented with symptoms of COVID. He was admitted with suspected COVID and placed on a COVID floor with other COVID patients. And why that's important is because of these issues with staffing, the issues with aides and nurses becoming sick with COVID. They're losing staff members. They have increased nursing to patient ratios. This is the reason the legislation was enacted, was to provide this temporary relief for a period of months between March and July to give some leeway or latitude to healthcare workers that were on the front lines, that were experiencing this, the onset of this pandemic and learning how to navigate their way through it. And so the whole discussion that we've been having now is really just the in support of language. Was McLaren providing healthcare services in support of the state's response to the pandemic? I think unequivocally yes, for all of the reasons that we talked about. Now the question becomes, is there some connection? Was Mr. Rogers injured or passed away by reason of healthcare services? And I think where Mr. Granzato strays a little far from the path and the legislative intent and what this court has held in Warren, Skipper, Baines, and Jokinen is that he's suggesting that the COVID-related treatments need to be provided specifically to the patient who's claiming injury. That is absolutely not the case. That's never been held by this court. That's not in the statute. That's in none of the legislative history materials. And makes less sense when you consider that COVID positive testing is not even required to effectuate immunity in this case, in any case.
Doesn't that read out of the statute, the phrase by reason of?
Is the COVID positive testing?
The position you just took seems to take that phrase, that clause of the first sentence of the applicable statute, right out of the
As far as the COVID positive testing, or I just want to make sure I'm understanding your Honor's question.
Well, I don't know. Just proceed.
Yeah.
Let's go ahead.
So
We'll get back to it.
I think we need to go back to the Warren opinion because I think the breadth of the statute is really borne out in that opinion. And when we initially filed this briefing, this was back in July of 2024. So we've had a lot of expansion on the case law and discussion about the statute in and of itself since then. But I think the breadth of the statute is what's important. I think the some connection requirement that's delineated by this court in Skipper Baines is incredibly important because this is not a situation where Mr. Rogers needed to be treated for COVID. And
That's my point.
yeah.
By reason of those services.
So
I mean, he wasn't receiving, because in point of fact, I mean, you could talk about false negatives. He tested negative. So he wasn't receiving COVID services. His injuries weren't by reason of those services.
I see what Your Honor is saying.
Of
So
course, I mean, that's the whole
Yeah,
issue.
so-
So you should see it.
I think the issue is we need to get back to Nurse Marius's testimony that she was essentially called away. This is the key piece of testimony from her. Had she not been called,
She wasn't called away. She just wasn't available. She just wasn't there. She wasn't called away from this patient, as far as I understand.
so,
the record.
okay, so there's two individuals that were involved.
Right.
So Mr. Rogers had his assigned nurse, Nurse Marius.
Mhm.
She was responding to a rapid response call
Yeah,
to transfer a COVID patient to the ICU.
right.
The nursing aide, Miss Selva, was with the patient in the shower at the time that he was showering, and then she went to go get the towel and she came back.
You have a patient who didn't have COVID, who wasn't receiving COVID-related services. He was being given he was taking a shower.
Yes, but I think that
So-
the issue is had Nurse Marius not been assisting a COVID patient with a transfer to the ICU because of his COVID, he would have never been in the shower in the first place.
We don't know. We don't know
Yeah, but
that.
doesn't that get back to the same, I guess, the same line of thinking that the chief is saying is get back to my example of the broken ankle in the emergency room. If the nurse got called away to assist with a COVID patient who is coding, three beds down, you're saying that, the person with the broken ankle, that service is related to COVID?
I think so. I think that's correct. I think that's a correct interpretation, given the breadth of the statute, because when you get back to the core of what this statute's about, it's not about, hey, you're immune from liability if you are treating a COVID patient who's receiving COVID services and they're injured by reason of those services. Warren specifically says that treatments that are immune are COVID-related treatments and non-COVID, regular healthcare services that are rendered in support of the state's response to the pandemic. So yes, absolutely. If a nurse is with a patient and they're called away emergently to assist another patient who has tested positive for COVID or is coding because of some COVID-related process and is being transferred, and that patient who was left with an aide, someone who's not a medical professional, and some injury occurs because the nurse is not with him, I think that's covered within the statute.
That's a great theory. Isn't it foreclosed by Jokinen?
So I think Jokinen needs to be read with a slight grain of salt, only because that was a C8 analysis. So there was actually no discovery that was undertaken in that case at all, and it was decided on the pleadings. And so I think with the Jokinen decision, because there was no facts alleged in that complaint that dealt with this whole issue of COVID, this court essentially said, well, all of these theories that are raised by the defense in that case, they're not sound because they're not in the complaint. There's no discovery on this issue. So I think Jokinen, while it does provide some explanation as far as what does this some connection requirement mean, I think it's a little bit different considering that there was no factual development. I believe it was a motion for summary disposition filed in lieu of an answer to the complaint. So I think it's slightly different on that aspect. But
Okay, anything else for us on?
no,
Unless
the court has any
Okay.
questions on the remainder of that issue.
you want to address the gross
Yeah,
negligence?
of course.
Okay. And Judge Boonstra, feel free to jump in at any time. I've been negligent in not inviting you to do that.
All right, so our gross negligence issue that we have before the court, I think is a little bit more straightforward than the COVID immunity issue. So in the trial court, we brought alternative claims under C8 and C10. One of the issues that we had in this court, saw probably in the transcript from oral argument in this case, is that the trial court didn't really consider the C8 bases of the motion. It really kept harping on the question of fact issue. There's a question of fact as far as gross negligence. It's really a C10 analysis. I know plaintiff's counsel in this case makes the argument that, well, when you attach exhibits to a C8 motion, that it transforms it into a C10 analysis. But I agree that the Kincaid case says that in that case that was brought under C8 and exhibits and extrinsic evidence were put forth in support of those arguments, then the court correctly undertook that analysis. However, in this case, we've never submitted extrinsic evidence as part of our C8 arguments in this case. We've only ever relied on the four corners of the document, of the complaint itself. And the problem with the complaint itself is, once plaintiff amended the complaint to add the count of gross negligence, effectively nothing changed other than the procedural labels. So in the amended complaint, the phrase gross negligence appears 3 times. Conduct so reckless, you know, the definition of gross negligence, appears once, but all of the factual allegations are the same. All of the legal theories as far as how McLaren is liable are just standard of care allegations that were alleged in the original complaint. Things like fall assessments, being with the patient at the time of the fall. So
Is your position though, are you saying that the same facts can't support both negligence and gross negligence? You don't get to gross negligence unless you have ordinary negligence.
correct. And I think the problem with the facts alleged in the complaint is that while they may state a claim for ordinary negligence or nursing malpractice, they don't rise to the level of gross negligence. The case law that we cite is clear that gross negligence is something substantially more than ordinary negligence. There needs to be almost a willful disregard of safety precautions that suggesting you don't care if the patient or whoever is injured. So I think that in some world, the facts alleged in a medical malpractice complaint could theoretically rise to the level of gross negligence. However, in this case, I don't. Simply alleging that the nursing staff didn't do proper fall risk assessments, or they weren't with the patient at the time that he fell in the shower, that's ordinary negligence. That doesn't rise to the level of gross negligence. So I think if this court should reverse the trial court and instruct it to hold that based on the face of the pleading, they have failed to state a claim for gross negligence. Now, getting to the C10 arguments, this case is anything but, the facts of this case are anything but gross negligence. Plaintiff cites to the Ray versus Swagger case where the individual is hit by the car when they're running through the intersection with the red hand. This is not like that case at all. This is like the name of the case escapes me, Torella opinion, where those football players were going to do that 3-day conditioning, and there was a bunch of precautions that were put in place to make sure that the football players were safe. Things like physical examinations, testing, things like that. In this case, we're more in line with Torella than we are with Ray versus Swagger. This is not a situation where, a great example, the Anderson opinion by this court involves a fall of a patient who did not have COVID, where she came into the hospital, she was having suicidal ideations, and she was allowed to shower alone. She fell and she fractured a bone, and immunity was applied in that case and affirmed by this court, which is analogous to this case, because I think in line with those 3 cases, Anderson, Ray, and Torella, Miss Selva, the nursing aide, did not just say, Mr. Rogers, you know, the shower room is across the hall. Go take a shower. I'll be here when you get back. She brought him to the shower room. She sat him on the shower chair. There are grab bars all around him in the shower. There's an emergency pull cord if he needs to call for assistance. She brought supplies like towels, and she was going to remain next to him the entire time.
But she didn't, though.
She didn't, because in her deposition, she talked about the shower curtain kind of being slightly ajar so she could keep eyes on the patient. And the floor, when the shower curtains, open a little bit, the floor just outside of the shower is becoming more wet. And so she wasn't anticipating that. So she needed to go get additional towels, which were just around the corner. And she was gone maybe 15 seconds, but she didn't just leave. Before she left, she talked to Mr. Rogers about the need for the additional towels. She said, please don't get up from the shower chair. I'll be gone for a matter of seconds to grab this towel and I'll be back. Not only did she instruct Mr. Rogers on that, but he gave a return understanding and affirmed that he would not be getting up from the shower chair. This was not a patient that was losing consciousness or coming in and out of consciousness or had neurological deficits or cognitive deficits. He knew what was going on. He was aware of the situation. He said, Joyce, I will not get up from the shower chair. He was alert and oriented. He understood the instruction and explained that he wouldn't do that. When she was gone, for whatever reason, he stood up from the shower chair, took a step out of the shower, and he fell.
We understand. I think, in my mind, it's not even close to gross negligence, but maybe Mr. Granzato can convince me otherwise.
I appreciate
Anything
it.
else for us?
No, I just reserved some time for rebuttal to talk about the gross negligence issue.
Judge Boonstra, anything? Looks
No
like it.
question. No
Okay, you'll have
questions.
time
Thanks.
for, okay,
Thank you very much.
you'll have time for a rebuttal on your cross appeal.
You don't have to reach gross negligence. Gross negligence is a way around the immunity statute. The immunity statute doesn't apply here. Okay, on the basis of.
If we agree, then do you dismiss the gross negligence claim and you just stick with ordinary negligence, or do you?
Yeah, I would be willing to do that. But there'd be no reason to have gross negligence in the complaint if the statute doesn't apply. And that's why you don't have to address gross negligence, because gross negligence is an end around the statute. To the extent the statute does not apply, gross negligence doesn't have to be reached by this court. Okay, there's no reason to touch it. Okay, now I would say that for what it's worth, on the C8 aspect of this case, the complaint says gross negligence. And your point is very well taken. The plaintiff can't change the facts. And the fact is, once you plead gross negligence, you have to stick with the facts you have. It's not particularly surprising that the facts are going to stay the same in an amended complaint, which includes gross negligence. The only question is whether those allegations meet the gross negligence standard, which admittedly is high. I acknowledge it. It's the same as 1407 that we deal with all the time. May I just take the time just to clarify certain facts, because certain facts in this case have to be understood. Okay. Nurse Murray comes, according to her testimony, comes to Mr. Rogers and says, "You're not taking a shower, and you're not taking a shower because I'm not going to be there with you. I'm not going to jeopardize the health of my children." She's afraid of going into the shower. That's what Nurse Murray testifies to. Okay. And she says she's totally surprised when she finds out that Mr. Rogers has fallen.
Wasn't there a doctor's note in the record
Yes.
approving him for a shower?
That's correct.
Okay.
Okay. But here's the strange part of this. Ms. Selva testified in her deposition that Nurse Murray said, "Go take Mr. Rogers to the shower." So we have Nurse Murray saying, "Oh, I was shocked to see that he had fallen because he wasn't supposed to be in the shower." Whereas the assistant says, "She told me to take him to the shower." Now, there's an obvious conflict in the testimony. The other thing to understand is this emergency, according to Nurse Murray, involving a COVID patient, that I acknowledge, was in the next room over. In the next room over. And according to the testimony, the shower was across the hall from Mr. Rogers' room. And when you read Ms. Selva's testimony, what you will see is when she heard from the outside the door, because she wasn't there, but when she heard Mr. Rogers fall, Nurse Murray was right next to her, right at the door. So this whole idea that there was some sort of COVID emergency which took her away, she was at the door at the time he fell, just so you know. Okay.
There were COVID patients on that floor.
Yes, there were. That's correct. One of whom was not Mr. Rogers.
Right.
Okay, so the facts that they've tried to present here are a little bit distorted, okay? But even if it were true, even if Nurse Murray said, "Oh, I would have been there. I would have been there in her place. There would have been two of us there." If if they could prove that, we would get back to your hypothetical. Okay, she is called out on an emergency basis for a COVID patient. Okay, but that's not what she testified to. What she testified to is, "I was never going to go in there because it was a danger to my children to go in there and be in that shower." So
Because of COVID.
yes, exactly. because of fear of her getting COVID, not from Mr. Rogers, but from the vapors in the shower. She knows more about COVID than I do, obviously, but that's not the treatment. The medical services being provided to Mr. Rogers, which are at the center of this whole thing, getting back to joking.
Anything else for
No.
us?
I-
Okay,
Mr. Gonzato, can I ask you a question before you sit down?
Pardon me?
Can I ask Mr. Gonzato a question? before he sits down?
absolutely.
Yes, if you speak very loudly.
Yeah, we're having a little trouble hearing you.
Okay,
That's-
sorry.
That's better.
So as I understand the facts, and you can correct me if I'm wrong, obviously, the nurse assistant who left the shower for 15 seconds or so to retrieve additional towels, before she did that, my understanding is she called out to other hospital staff for them to bring her towels, but that because they were short-staffed due to COVID, there was no one available to do that, which is why she then left. Is that factually correct?
I do
And
not
is that
believe-
enough to bring it into the statute?
No, I don't believe that's the facts that I've read. I can be corrected, but no, that's not how I read her deposition. I do not think she did that.
If that were true, would that be enough to bring it within the statute?
Well, what connection do you have to COVID? Are you talking about staffing?
Yes.
Okay, well, I think the staffing is sort of a dead end for the defendant in this particular case. Precisely because what would staffing be beyond a one-person assist? And that's what he got, a one-person assist who abandoned him. So I don't see staffing as something, at least the way the circuit court looked at it. Now, you're talking about something different. I don't know quite how the defendant would prove it, that nobody was within earshot who could respond to her request. But the fact is, it would be very difficult to prove, even if they had it. How are you going to prove that there was somebody in the hallway, or would have been somebody in the hallway if they hadn't been short-staffed? I don't know, but you're getting closer. You're getting closer to the statute.
Okay.
right.
Thank you.
Counsel, any rebuttal on gross negligence?
I have no rebuttal on gross negligence. I can answer any questions the court has on either issue, but
Any questions? Judge Boonstra, all set? Okay, very good.
all right, thank you
Thanks
very
very
much.
much. Well argued. Thank you for your arguments. That case is submitted. We will take a very brief recess and then be back to hear item 1. All right. Back in session with Judge Mariani in tow. So we can return to our day 1 case call. And I don't need to repeat myself. You were all here when we got underway with item 10. So we'll just move directly to item 1. Docket number 372-429, People of the State of Michigan versus Jalon Emilian Martin.
Good morning, Suzanne Gabar on behalf of Ms. Martin. First, I want to acknowledge that Ms. Martin absconding from probation is a serious violation. My intent it was never my intent, nor is it my intent in any of my briefings to minimize that. However, this case involved a very unique set of circumstances. This is a person who comes from a very troubled childhood, which warranted the deviation in the first place and her being granted HIDA. I disagree that absconding automatically mandates a heightened sentence. I think courts should always look at the circumstances as a whole, the defendant itself and the offense and the offender combined together, not just the circumstances that brought the defendant to a probation violation.
The defendant didn't just abscond, right? Also picked up new charges along the way.
At the time, there were charges pending. How those charges resolved was outside of the sentencing, because at the time they were just pending whether or not she was found guilty, whether they were dismissed. At the time, they were just pending. The resulting violation that she ended up pleading to was absconding.
Right.
I do want to focus on the probation recommendation. While the trial court is not bound by it, I think it gives context as to why probation recommended what it recommended. One was Haida be revoked. Obviously, the reduced charge of unarmed robbery would be a conviction because Haida would be revoked, and then she would participate in 90 days MDOC with a curfew tether. That was aimed to ensure compliance, and I think that took into account Ms. Jo Martin's history in the case. Again, this was a person that really had never any kind of guidance in her life. With the tragic death or her witnessing the death of her mother, being put in foster care, being sexually abused. I mean, it was one thing after the other. And even what brought her into the circumstance and the case she was convicted into was also her susceptibility to being managed by individuals, because she's kind of been managed and dragged her whole life. Again, I'm not minimizing that she didn't follow through. However, I believe it was a reasonable punishment that Haida was revoked, even though her counsel at sentencing was arguing that Haida shouldn't be revoked. Haida was revoked. She's got now a felony unarmed robbery on her record. And at the time that she pled, she was still under 25. That in itself is not a light punishment. To now have to serve a prison sentence on top of all of that, I don't believe that was a reasonable sentence under all the circumstances.
It was within guidelines, wasn't it?
It was within the guideline sentence, but under the decision in Posey, she very much can argue the reasonableness of the sentence. And there's one thing I do want to note of the court to consider. When the judge was handing down the sentence, he addresses the dismissed charges, original charges of armed robbery, and says the guidelines to that were 51 to 85. Then he addresses the unarmed robbery guidelines of 36 to 75, and then was perplexed by the recommendation of MDOC saying this was a tremendous deviation. By grouping those two charges together and the guidelines together, it seems to me that the court is considering the original charges, the original guidelines. While the court can consider dismissed charges, I don't believe it was reasonable to consider that this is a deviation.
Well, the court
from
can consider the facts.
The courts can consider the
Right.
facts,
Okay.
absolutely. However, in mentioning that the guidelines were 51 to 85 and considering the reduced guidelines, it seems to me when you read the transcript is that the court is considering this being a tremendous deviation from the 51 to 85, not the 36 to 71. Court handed down a 60-month sentence, top end of the unarmed robbery, and certainly a higher end.
Not the top end. It was 71 months. at the
71
top
is
end.
certainly significantly high.
Yeah.
It's a high on the lower end. I think that if you consider the mitigation factors, and again, while they originally warranted the Haida and the probationary term that she received, those facts don't go away. They're still there. And I don't believe that it was reasonable for the court just to kind of throw down the towel and say, I'm sending you to prison without giving her an additional opportunity with some stricter guidelines, or at least even a shorter term of sentence. So I asked the court to remand it for resentence because I don't believe the judge reasonably articulated this sentence to Ms. Martin and the circumstances of the offense.
Any other questions for counsel? All right, Ms. Gabarra, you will have time for rebuttal.
Thank you.
Good morning, Your Honors. Marilyn Day, Assistant Prosecuting Attorney representing the people of the state of Michigan. This case comes down to one simple question. Did the trial court abuse of discretion in imposing a within guideline sentence after he had allowed defendant to be sentenced to a HIDA and probation and deviated substantially from the guidelines? The trial court's decision in this case did not fall outside the range of reasonable principal outcomes. It was not an abuse of discretion, and the sentence in this case was proportionate. Defendant was originally charged with carjacking and armed robbery. The prosecution, because of the defendant's background, and I do believe that the defendant's background would have warranted the original sentence in this case. But we allowed the defendant to plead to the lesser offense of 2 counts of unarmed robbery. Judge Warren recognized that her background had some sympathy, that he had some sympathy for the defendant. So he, in fact, allowed defendant to get HIDA, went below the guidelines and gave her 30 months probation. Having done that, he specifically told defendant sentencing, I'm giving you a break. If you come back, I'm going to exceed the guidelines. He told the defendant, he knew that she had a chance to be rehabilitated. But what did she do? A year and a half into her probationary sentence, she just stopped going. She stopped having any contact with her probation officer. Her reason, which is set forth in the PSIR, my probation officer stopped talking to me and I lost the phone number of the probation office. That was her only explanation. A year and a half in, but she wasn't picked up for another year and a half. So it was 3 years from the time that she was sentenced to the time she was picked up. If she had been following probation, she would have been done. Her conviction would have been gone because she would have been on HIDA. But for the 3-year period where the court originally had hoped that she would be rehabilitated, she did nothing. If you look at the probation violation report, she didn't do anything that she was ordered to do. She didn't complete schooling. She didn't do mental health assessment. She did nothing. So when she was originally picked up, and she was picked up because she was driving a car with a no license plate. And when she was picked up, she was arrested because she was driving without a license, and she was arrested for receiving and concealing stolen property because the car she was in was stolen. She told the police she didn't know the car was stolen, even though the back window was broken, there was glass in the back of it. So if you look at all the circumstances, you can even exceed the guidelines for a probation violation. It shows that the defendant has a callous disregard for the system. And that is what the court did in this case. The court looked at all the circumstances, recognized that the defendant had a traumatic childhood, but specifically indicated and was not looking at the guidelines for the armed robbery, but was specifically looking at the guidelines for the armed robbery. And the court's specific reasons for imposing the sentence was the impact of the conviction on the victim. The victim was stabbed. The defendant was with her boyfriend, lured the victim into a hotel where they robbed him, stabbed him, and took his car. The court indicated that another reason for the sentence was a failure to take the grace of the court and the people. The court can look at that when it's imposing sentence. And because of material violation of probation. This was a non-technical violation. Defense counsel in her brief says, well, this is all the other things that the court could have done and cited to the statute that was addressing the technical violation. This was a non-technical violation because she absconded from probation for over 18 months. And, we didn't even do a probation violation that she picked up new charges, but we could have done so. So I asked this court to affirm defendant's conviction because Judge Warren did not abuse his discretion in imposing a within guideline sentence in this case. Answer any questions.
For counsel? All right, thank you.
Thank you.
Ms. Gabarra?
Very briefly, I do want to note, according to my notes in the plea transcript, at page 4, it was her co-defendant who had the knife. It was not Miss Martin. This was a relationship, again, where Miss Martin was kind of the scapegoat. And again, this is a person that really never learned what consequences were because she never had any kind of guidance. Again, not minimizing that she absconded, not minimizing that she, yes, could have avoided an unarmed robbery felony conviction on her record and would have had a clean slate. But perhaps a person who didn't have that baggage would have realized what that meant, but not someone who never really had any guidance in her life. Again, and also when you say she had disregard to the system, yeah, with somebody maybe that didn't have her baggage, I would say yes. Again, I think that the sentence is unreasonable, mainly because of her circumstances, mainly because of the background she had. The just punishment that she got was the felony when she's under 25 years old, be stuck with that felony that's going to follow her for a very long time. And even with a prison sentence, it would not be the sentence that was handed down. I just simply don't believe that the court considered all the facts, and this was purely an abuse of discretion under the standard now we have in Posey. Thank you.
Thank you. Appreciate your arguments. Thank you for appearing here today. That case is submitted. Thank you very much. All right, that brings us to item 2, docket number 369088, People of the State of Michigan versus Michael Deshawn Altman Tucker.
All right. Good morning, Your Honors. May it please the court. Tim Doman on behalf of Michael Altman Tucker. I don't intend to take too much of the court's time this morning. I think the issues are pretty well covered by the briefs for the most part. We have a single issue in this case, and I think it's very straightforward. As I read the case law, in a murder case, if accident is asserted as a defense, and if an accident instruction is in fact given, then the court also has to give the involuntary manslaughter instruction. Obviously, that didn't happen in this case, and so I think that we have error by the trial court. And I honestly don't see how this court could decide otherwise. So then the question, of course, becomes harmlessness, right? And under the case law, the inquiry is whether there was substantial evidence supporting the involuntary manslaughter instruction. And here I think there was. I think this is kind of a rare case, at least in my experience, where we have video of what happened here. And yes, the video is somewhat grainy and we don't see exactly how the gun went off because Mr. Bing was in front of the camera. But suffice it to say, I think the video corroborates my client's account of a struggle over a gun and an accidental shooting. And as the cases all say, that's a really classic involuntary manslaughter scenario.
Counsel, doesn't the testimony also show that one defendant knew he was supposed to not have a gun in a bar?
Correct.
2, he put his hand and secured the gun leading up to when it discharged. And 3, you have eyewitness testimony stating that he told the bouncer, come outside and I got something to show you. Doesn't that suggest some sort of thought and intent as opposed to an accidental?
So taking the last point first, the testimony on that was disputed, right? There were a few witnesses who said, I heard him say this. There were other witnesses who said, I didn't hear him say anything like that. And Mr. Altman Tucker himself testified, I never said that. So there's a dispute in the evidence. And I don't think this court can say, well, we, like this version of the facts better. So we're going to decide this witness is more credible.
But does that rise to substantial evidence?
I think because my client testified, I never said that, this was accidental, I never meant to shoot him. I think a defendant is entitled to have a jury instructed in accordance with his theory. And the evidence did not inescapably refute my client's testimony or the video. I'm trying to remember the other points Your Honor had.
That he secured the gun
Correct.
as he was being let out of the bar.
Certainly. And I think my client would even admit that probably that rises to the level of negligence at a minimum, right? A couple important points. He never pointed the gun at the decedent and he never even brandished it. He just held it at his side and then the bouncer tackled him. So I take Your Honor's point, but I think if anything that speaks to, yeah, this is more so an involuntary manslaughter case rather than pure accident. So I acknowledge all Your Honor's concerns, but I think that just shows why this was more so an involuntary manslaughter case than anything else.
Now, what do we make of the jury's verdict? I mean, obviously, it's very difficult to get inside a jury's mind after the fact, but we do have some decisions that they made in terms of, rejecting a complete defensive accident.
Right.
We have a corresponding conviction of assault with intent to do great bodily harm. So, I mean, how do I know that just from that constellation of decisions about this dispute, that there's actually any reasonable space here that the jury could have concluded that there was, some intent less than great bodily harm, some gross negligence, rather intent to do great bodily harm, that the jury would have actually acted on had it been instructed that way?
Sure.
What tells me in the record that there's substantial support for that?
No, that's a great question. And I think it's very important, and it's in my brief, and maybe I could have highlighted it more, but with the assault charge, my client was not convicted of assault with intent to murder. He was convicted of assault with intent to do great bodily harm. And so I think that shows if the jury really believed that this was some type of intentional shooting.
Was there an option on that conviction to convict with a lesser intent than that for the jury?
I'm not sure about that, Your Honor. I can't say for sure, but certainly I think given that my client was not convicted of the AWIM, he was convicted of a lesser offense. To me, that supports this idea that the jury wasn't willing to acquit him wholesale, right? They thought that he was for some culpability in this case. And so I think under that circumstance, involuntary murder, or excuse me, involuntary manslaughter is really the charge that fits most neatly, considering that he was acquitted of AWIM.
And what about the voluntary manslaughter rejection of that charge? Tell me what meaning, if any, there is.
I don't think there's really any meaning. Voluntary manslaughter is a very unique crime in our law that requires heat of passion, adequate provocation, and the case law is clear that in these types of struggles over guns and things like that, that voluntary manslaughter is really a square peg in a round hole. So I don't think that really tells us anything. Although to a certain point, voluntary manslaughter is an intent crime, right? So here they may have felt that depraved heart murder, given their options here, fit more neatly than voluntary manslaughter. So I'm speculating now, but I don't think that necessarily tells us that much.
Okay, understood.
So, yeah, I wanted to address the point from the prosecution's brief where they argue that the video depicts a clearly intentional shooting. I find that to be a misrepresentation. I mean, you watch the video, it's clear that there's a struggle over the gun. You can't say that this, my client, in cold blood pointed and shoot it. It's much more consistent.
But there are 3 shots, right? So this isn't just like the gun went off once.
Correct.
And obviously the struggle continued, but it also wasn't 3, bam, bam, bam.
Correct.
3, 1, another. So, I mean, again, how does that pattern square with the idea that this was just strictly accidental occurrence?
As I watched the video, all the shots went off while they were fighting over the gun. So I think the fact that it was 3 doesn't really tell us much about whether it was intentional or not. I mean, if there had been a disengagement and then shots fired after that, obviously different story. But as I view the video, all the shots go off while they're kind of in the heat of battle there. And I think the other thing is
what is it they're struggling over?
The gun.
Why didn't he let it go?
I think he testified he was afraid for his life at that point, that the bouncer was aggressively pushing him toward the door, really unnecessarily. He was on his way out anyways. So, and then if you watch the video, my client reaches for the door, Mr. Bing pulls him back in, and that's when there's the struggle over the gun. So, and I think the other point is that if this was so clearly some type of intentional shooting, then why is the trial court giving the accident instruction in the first place? So I think certainly a rational view of the evidence did support involuntary manslaughter.
Any other questions? All right, you have time for
All
rebuttal.
right, thank you, Your Honor.
All right.
Good morning, Jonathan Mysek on behalf of the people appearing for Chief Josh Abbott, Chief Appellate Attorney Josh Abbott, who wrote the brief in this matter. I'll primarily rely on my brief and just respond to a couple of points that defense counsel has made. The idea that the defendant never pointed or brandished the weapon in this case, I think, is, I'm not going to say it's disingenuous, but it's definitely close. Additionally, the idea that people have misrepresented some facts about the weapon and the video and the shooting being intentional is also incorrect. Defense counsel is correct in that we have effectively a silent witness to the actual shooting circumstance. We have the video that's uncontested, and specifically at the People's 8 camera 9. The video that shows the inside the vestibule at 11:41:01. Now, I believe that defense counsel has.
Are you referring to the video that opposing counsel supplied in connection with their reply brief, or tell me what you're pointing to?
I don't recall, I don't recall, seeing the video that was, that was supplied by, defendant in his, reply brief. I don't recall getting that from Chief Abbott either. I don't see that in our file. I will, take a look at that when I get back to the office, and if People's 8 has not been provided to this court, I will provide it to you. But the exhibit People's 8, at time code 114101, that's the timestamp on the video. The defendant is pushed to the wall adjacent to the door, but his arm goes out to the right. It's not reaching for the door. There's a pistol in his hand. And at that point, you can see the victim, Mr. Bing, tackle the defendant at this point. And as he's coming in, the defendant takes the hand with the gun, and he doesn't drop it. He brings the arm into the void between him and the victim. And then as you point out, Judge Mariani, he fired the gun 3 times. And so the idea that there was any kind of accidental shooting or that there was any kind of struggle for the gun is not supported by the rational view of this evidence. Now, as to why the court gave the
Can I
accident.
just interrupt for a second?
Sure.
Yeah, I mean, isn't it, it does seem kind of strange that we have all of these instructions surrounding the fifth theory of the case and then just this one missing.
Mhm.
And including accident. And I mean, I understand your point in terms of you don't feel like the evidence, would support that. But, if the jury had just been given that instruction, then maybe we're not here at all.
Most likely.
So,
And so I can't I can't understand, I don't know why the court gave the accident instruction, but it did. And so should it have given the involuntary manslaughter instruction? Hindsight 2020, perhaps it should have. However, it's still the people's position that based on this evidence, it wouldn't be a rational view of the evidence. It's not supported. And because it's not supported, it couldn't have been given.
On your view, neither one supported, neither accident nor involuntary manslaughter.
Well, right. I don't believe Chief Abbott took a position on the accident. But so I'm stuck. And so I'm limited to the arguments that have been previously presented. But as articulated in the brief, that there is no rational view of this evidence that would support the giving of the involuntary manslaughter instruction. And so the court was not erroneous for not giving it. And even though it didn't give it, when you look at Hawthorne and the application of harmless error, if the failure to give the instruction, it was in fact harmless, given the fact that the trier of fact, the jury could clearly see what happened. Well, and I should say clearly, because I should say that some of the video is in fact pixelated, but they can see what actually occurred and then draw on the other witness testimony to provide the appropriate context. And so ultimately, there is no error here. I yield for any questions.
Any questions?
nothing
All right.
more from me.
Thank you. Any rebuttal, counsel?
Just very briefly. So I guess even when we have video, we have disagreements about the record in this case. I think the video speaks for itself. My view, it clearly depicts a struggle over a gun, but I guess everyone can form their own opinion on that.
Would you agree with your brother counsel's statement that there is a part of the video where it shows the arm extended with the gun in the hand? Is that depicted in the video?
I believe toward the end, you do see that. And I think that is when the final shot is fired, if I'm remembering correctly. But I think that is still at a point where Mr. Bing and my client are engaged together, that he still has his arm on him. And again, very pixelated, grainy, so we don't know exactly for sure how everything played out. But I think that holding the arm out straight doesn't refute the involuntary manslaughter theory.
So help me understand, would it be your position that anytime a court gives an instruction on accidental based on the defense theory, that they then also, it's mandatory to give involuntary? Or when would you have the option?
I don't need to say, because this court has already said it in People v. Hess. So that's black letter law, that if accident is given in a murder case and voluntary manslaughter is also given, you have to give the involuntary manslaughter. So I think I heard from brother counsel that he agreed that involuntary manslaughter should have been given in this case. And so really, to me, this is obviously a question of harmlessness, and looking at the evidence and looking at my client's testimony, which again, people can disagree about whether about the version of events, but the defendant is entitled to have the jury instructed in accordance with his theory of the defense, and that didn't really happen here. One last thing I wanted to touch on, there's a couple questions about, well, why didn't he just drop the gun? Again, these struggles over guns, it's a very typical involuntary manslaughter scenario. No, I haven't read any case that said, well, it's not involuntary manslaughter because he could have dropped the gun. That's not what any court, to my knowledge, has held. These are, fast moving circumstances, heat of battle type thing. And I don't think it's, reasonable or expected to say, well, he could have dropped the gun, not knowing what this bouncer who towers over him is going to do at that point. So
could have not taken the gun out in the first place. I mean, he's just being escorted vigorously.
I agree.
Out of the bar. Could just leave.
Completely. No, and then, like I said, I think certainly this is a case where the jury could have said, we don't want to acquit him. We don't want to, rely on accident. But, they could have found him guilty of involuntary manslaughter at that point, that, okay, he shouldn't have brought the gun into the bar. He shouldn't have taken it out, but that does not rise to the level of wilton, wanton, depraved heart murder. It's more in line with involuntary manslaughter.
Counsel, would you concede that both the cases relied on in your briefing, Hess and Martin, those predate this court's articulation of the standard on involuntary manslaughter, that it's if supported by a rational view of the evidence?
Yes, I think those cases predated Cornell, which is kind of the main case about, when is it error to not give an instruction. So I think that redefines harmlessness, or at least gives a clear picture of how to consider harmlessness in these types of cases. I don't think that affects the initial decision of, is this error or not?
Well, didn't the Supreme Court in People v. Heflin reject that Jones stands for the proposition that anytime a trial jury instructs, didn't they reject that anytime you give an accidental instruction, you're required to give the involuntary manslaughter?
I didn't read Heflin that way. I don't think the prosecutors argued that. So, and obviously Hess comes after Heflin, if I'm remembering correctly. So if that was the case, obviously this court would have come out differently in Hess. But so yeah, there has been changes in the law, but it's all on the harmlessness side, not is this error in the first place.
I understand.
Any other questions? All right. Thank you very much.
All right,
Appreciate
thank you,
your
Your Honors.
arguments. Well argued, cases submitted. All right. Item 3, docket number 372095. Mary Nick Prolage v. Stephen Michael McConaughey. Anytime, counsel.
Your Honor, we're going to rest on it.
Step up. Give us your appearance.
Sure. Good morning, Attorney Joseph Didvukai for the appellants, and we are resting on our brief and reply brief.
Any questions for counsel? Thank you.
Good morning, Courtney Evans on behalf of defendant appellee, Mr. McConaughey. Also here I have Tim Deemer, also on behalf of defendant. Appellant's counsel, who's not interested for oral argument. I just have a couple brief points. And
thank you.
And we'll happily answer any questions that you may have. The trial court's grant of summary disposition in favor of the defendant should be upheld in this case because defendant produced clear, positive, and credible evidence that he suffered a sudden emergency in the form of a mechanical failure that led to the failure of his brakes immediately before the accident. Defendant supported
What's
his.
the evidence of brake failure?
So in this case, he took his car or had his car towed immediately to the auto body shop, and they produced a receipt that says that he had a broken drive shaft.
Well, right, there's a drive shaft.
Correct. But in this case, plaintiff produced no evidence that shows from any expert, from any mechanic, that showed that the failure of a drive shaft could not impact
Well, don't you,
breaking.
your evidence in the first instance needs to be sufficient to entitle you to judgment as a matter of law. Then it's their burden to say, oh, no, there's a dispute about that, or there's something missing. But I don't understand how showing evidence that one part of a car was damaged after the accident, it provides any positive proof that another part of the car was damaged before.
Your Honor,
How can you get judgment as a matter of law just with a receipt of a broken drive shaft on the basis of a mechanical failure for brakes?
so I'm not an auto mechanic. I assume that, plaintiff is not an auto mechanic either. And without any rebuttal evidence to show that the broken drive shaft did not impact either the ability to brake or the feeling of braking or the transmission of power within the car, which I believe is what the drive shaft deals with, that is not sufficient to rebut summary disposition. We have defendant's affidavit that says, I pulled up to the stop, I tried to apply my brakes and it didn't work. And at that point, that's what we have. And he supported that with an affidavit. We supported that with a receipt that showed that there was some key mechanical issue wrong with his vehicle.
This affidavit doesn't really say that there was brake failure, does it?
His affidavit says that he went to apply his brakes and his brakes didn't work. And
Well, he said that he applied his brakes and then he hit the vehicle.
Yeah.
So, I mean, I think you can apply your brakes and still hit something without those brakes failing.
some part of his car stopped him from doing what we all do every day, stopping at a stoplight, applying our brakes, and we expect our car to stop before it hits the car in front of us. He went to apply his brakes. Something happened, whether it was, at some point with the broken drive shaft, it stopped it
So I think
prohibited his car from stopping in a reasonable distance.
Counsel, I think where you hear the struggle that we're expressing is the connecting of the dots. It
Mhm.
seems you have a lot of dots around, but they're not connected to show brake failure. And so if we look at the affidavit, because if you look at the receipt by itself, it just says it fixed a drive shaft.
Mhm.
How do we know the drive shaft didn't get broken by crashing into the car? What evidence? There's nothing connecting that or saying that it wasn't because of that. It happened before the accident. And then again, if you just look at the affidavit, it says I applied the brakes and then I hit the car. It doesn't say I pressed the brakes and the car didn't decelerate or anything. It continued the same speed. There's a lot missing in that evidence. So explain to me how the defendant has met the burden in the first place?
So defendant.
Or I'm sorry, plaintiff has, or defend, I'm sorry.
Defendant,
met the
yes.
burden.
So defendant provided basically the evidence that could have been provided at that point. He provided an affidavit that said, in his experience, what happened is he went to brake at the stop and something failed in his car. His brakes didn't work. It didn't stop his car as we all expect it would when we would press our brakes when we get up to a stop sign. He produced the receipt that he took his car, had it towed immediately, and this was what was wrong. Something was wrong with his car. And basically every other piece of evidence that could have been found in this case, a police report, plaintiff didn't stay at the scene, so there couldn't have been a police report. The plaintiff never deposed defendant to poke holes in his story or ask him any further questions about what exactly he experienced. And so defendant produced his clear, positive, credible affidavit that said, this is what happened when I went to stop my car. It did not stop. I towed my car immediately to the auto body shop. They found this issue with it. And that was sufficient in the trial court's eyes to meet that burden. And the plaintiff produced nothing other than speculation.
Well, your client's presumed negligent under the statute, right? So this isn't like this isn't like a kind of, there's a statutory presumption that your client was negligent,
Mhm.
that then it's your burden to overcome.
That's correct. And this would not be the only case in which this court has held that when there is a presumption, even evidence that's just an affidavit or testimony from a driver was sufficient to uphold that grant of summary disposition. There's a few cases. I have copies of them if your honors would like. There's Lewis versus Cameron, which is.
Are they published or unpublished?
They're unpublished
Okay,
cases.
we don't need to hear about it. Any other questions for counsel or anything else?
No further questions from the questions.
Okay. All
Thank
right.
you.
Anything else? All right. Thank you. The case is submitted. My apologies, counsel. I overlooked that you are not endorsed for oral argument. I would point out in my own defense, there are 4 lawyers endorsed on defendant's side on this relatively simple auto accident case. I assumed you were one of the 4. So anyway, the case is submitted. Thank you for appearing here today. Appreciate it. Okay, that brings us to item 4. Docket number 371-747, Joseph C. Finch versus Maurice Gennari.
Scott Norton on behalf of the appellant, and both parties briefed pretty substantially and quite a substantial record after a 9-hour evidentiary hearing in the lower court. And we come to you as the appellant with respect to 2 issues. One, this was basically a battle of the expert case. If you looked at the record, there are 2 very seasoned, very well-known surveyors, and this is a riparian case. This has to do with the adjacent landowners who are arguing over the use of the water on Loon Lake. Now, our expert, Mr. Lapham, versus the expert of the appellee, Mr. Hughes, came to differing views. Our expert indicated, based on his experience, that not all water creates riparian rights. Not all bodies of water create riparian rights. In fact, man-made water, bodies of water, present a problem. In this particular case, we have the history that it was owned by the federal government at one time. And we also have tax records that show that the bottom lands are being owned by other people. So, and there's also a testimony in there that there's a dam that adjusts the water levels. So I'll put those 3 together, and you take the testimony cited in the brief, which refers to the transcripts, which were all provided, is that this is not riparian. And therefore, the use of the water is not to be determined under a complaint filed with respect to the use of the water at water's edge, which brings us also to the second argument. In the second argument, the plaintiff filed a complaint for injunctive relief, basically, in court of equity. And he sought a determination of riparian rights. He did not seek a quiet title action, which is a specific action provided
But
by.
counsel, why does that matter? It seems like the court, provided relief that was in line with what the case was about. These are the boundaries, and I've decided them, and relief should be entered. So why does it matter whether they also styled a count under quiet title?
They didn't.
Well, I know, but
Yeah.
why does that matter? Why
Because
does it render the
it has
judge's
to do-
relief inappropriate?
It has to, I believe it has to do with, the complaint that was filed sought a determination as to the use of the water. It did not seek nor or allege that they were also looking for the court in connection with a survey that was provided at a later date to redraw the boundary lines of the land. To change the boundary lines between the two adjacent landowners. That wasn't any, they were only looking for a determination with respect to the use of the water because there was a dock out in the water and and there was a dispute over its location.
Don't you determine the boundary lines to resolve that dispute?
You do use the boundary lines to determine what rights you may have out into the water, but it didn't ask. The complaint certainly didn't seek, nor were we given a chance to defend against the court taking the next step in this judgment, opinion, and order where he basically took land from my client and gave it to the appellee.
Well, you characterize this as a battle of the experts effectively, right? Isn't that when you opened your argument?
It is.
So this case was resolved following a bench trial, right?
It was a 9-hour, 1-day
wasn't
bench
a
trial.
motion for summary disposition. So why isn't the trial judge totally free to credit their expert and not your expert and make a determination on that basis.
Well, that's the error that we complain about in this appeal, that the expert, that the judge got it wrong, that the expert that we provided indicated that this is not riparian.
Are we in a position to make that judgment? I mean, that, the trial judge concluded
Certainly,
otherwise, sat through the trial, heard the evidence. We didn't.
I know you didn't, but the record certainly shows that that was an improper decision.
Do you have anything else for us?
I said,
Okay, thank you. You have time for rebuttal.
Morning, Your Honors. David E. Sims on behalf of the plaintiff appellees, Joseph Finch and Denise Zebarth. The panel, you've rained on my parade because I wanted to address exactly what you raised. Again, I'm really relying on the briefs, but I wanted just to address the points he made in oral argument, which you guys have, you're right on the money.
Your honors, not you guys.
I'm sorry.
Not you
I'm sorry.
guys.
I apologize for that, for the panel. In terms of the battle of the experts, as you indicated, Judge Godola, this is, goes to the credibility of these experts, and the trial judge is the factor, the finder of fact in this particular case, because it was a bench trial, absolutely determined and made very clear in his opinion that he found the plaintiff appellee's experts to be more credible, and he articulated the reasons why. He went through, I think, very methodically and laid that out. This court,
Can I jump in? You brought a claim for trespass, right?
I did.
In the initial, okay. Doesn't that necessarily require the judge to determine where the property lines are?
I was going to get to that. Yes, it absolutely does. I mean, so let me just jump right to that argument. So the argument about the quiet title, okay? They claim that that's the way I interpret what they're saying is that our claim was too broad, that by ordering the survey recorded, it improperly quieted title. But that argument really mistakes the remedy for the claim. The claim was for declaratory injunctive relief, and to grant that relief, to declare the writer to stop a trespass, as you indicated, a court must first find where the boundary is. Has to find, that's got to be a finding in the case, okay? That's not quieting title. It's an essential core function of the court deciding the dispute. And that's exactly what this judge did. Ordering the recording of the survey was just ministerial, okay? It's just to make it effective. In other words, make the finding of where that boundary line is effective so that people are on notice of where court found this to be. You don't need to quiet title, as you indicated, Judge Mariani. The court has broad equitable powers, as we've laid out in our brief, and the court exercised those powers, and we pled for that relief. We sought declaratory relief based upon the trespass and the nuisance, as well as injunctive relief. Permanent injunctive relief is what we received. So it really, that really disposes of that argument, I believe. That just this whole notion of quieting title and an unconstitutional taking, it just didn't happen. On the contrary, we litigated the case for 2 years, or at least close to that by the time the final judgment was entered. And we did extensive discovery. We had experts. We had a trial judge that sat through an entire trial. I don't know how they could make that argument under the facts and circumstances of our case. So unless the panel has some questions for me, I'm happy to sit down and.
Any questions? All right, thank you.
Okay.
Appreciate it. Counsel, any rebuttal?
no rebuttal unless you have questions.
Any questions? I think
No,
we're
not
good
for
to
me.
go. Thank you very much for appearing, both of you. Appreciate your arguments, and the case is submitted. Okay, that brings us to item number 5, docket number 368880. Relivar Home Care versus Mimic Insurance Company.
Good morning, Your Honors. Lindsay Peck on behalf of Mimic Insurance Company. We are the appellant on the merits and the appellee on the attorney fees issue. So I'm not sure how you want me to argue that, but I'll just
Yeah.
probably
I
start
think-
with the
Right. I don't know if you were here earlier. This is
Yeah.
Mr. Granzato's second, kind of do it the same way
Okay,
we did
sure.
in his earlier case.
Sure. Mimic is asking the court to reverse the denial of a motion for a directed verdict, vacate a jury verdict, and remand for entry of a directed verdict in favor of Mimic.
That's your first challenge. You're asking us to overturn a jury
Yes,
verdict.
understood. But our position is that, you know, this was admission of inadmissible evidence that amounted to reversible error. And just to begin, we are challenging the denial of a motion for directed verdict. The standard of review is de novo. I mean, they're trying to box us into this abuse of discretion, but even the evidentiary questions that form the basis of our motion were preliminary questions of law of admissibility under MRE 103B. So this is de novo review. And our position is that the trial court admitted inadmissible evidence that was reversible error. The first one is a nursing note where a nurse documented like a verbal order from a doctor that said, you know, this patient has a TBI and he needs this treatment. Our position that this is hearsay within hearsay, even if the document itself could be a regularly established business record, which that foundation was not even laid. There still is the problem with the narrative, which is hearsay. The fact that the doctor signed it, it's still an out of court unsworn statement that needs to, you know, the doctor did not testify as to the diagnosis, the need for treatment. He wasn't even on the witness list. So that's their evidence of reasonable necessity, and that's inadmissible evidence.
How does that note not fall under MRE 8034? Statements made for purposes of medical treatment or medical diagnosis in connection with treatment.
Yes, Your Honor, we actually cited case law to the effect that that exception doesn't apply unless the declarant is the patient, the one making the statement in need of treatment or diagnosis. I think it's the state of Gracie, something to that effect. It is cited in our brief. And to be honest, they Relevard, you know, cited that MRE 8034 I think in the motion in limine briefing. After that, it abandoned that argument and it kind of clinged to the trial court's ruling, which was, well, the nursing note wasn't admitted to prove the truth of the matter asserted. It was just admitted to establish the state of mind of the nurse. Well, the state of mind of the nurse is not relevant. And even if the nursing note was admitted for that purpose, it wasn't admitted for the purpose of establishing reasonable necessity. So we're still lacking evidence of an indispensable element of the PIP benefits claim. Which kind of segues to the next argument, which is about the EOBs and the evidence of partial payments. We objected to that again in a motion in limine before trial. So we didn't technically need to renew the objection during trial, but we did. On 408, which I argued also preserves 409 because it's, you know, offers of compromise, and 409 addresses medical expenses in particular. But our position is these are offers of compromise. They're inadmissible. The trial court, you know, didn't really give much of.
I mean, I guess how it's just paying the amount that you know, are willing to concede is owed, but not the rest. How is that I guess I feel like there's some steps between that and saying this was part of a settlement negotiation or a compromise offer. It's just saying, hey, this is what I'll pay you.
Well, we did cite case law to the effect, I think it was, I want to say it was Chowman versus homeowners. Is basically, yeah, these EOBs where they, you know, reflect partial payments are offers of compromise because, you know, they're trying to compromise the claim and pay partial. You know, when you offer it for another purpose, it can be admissible, but there was no other purpose offered. It was offered here to establish that Mimic wouldn't have paid Mimic wouldn't have paid anything if it hadn't conceded the reasonable necessity of the charges.
Well, I mean, doesn't it just show what they considered to be the amount that they owed? I mean, I get, why does it have to be more than that? You know, why does it, the fact that they disagree that they owe the full amount billed, how does that get you to an effort to compromise that amount? Or to settle the dispute? It's just.
Well, because they wouldn't have paid anything if they were going to contest the offer to compromise was paying this partial payment and
I could see your point
resolving
if you had offered to pay zero and, you know, then the amount that you did pay was somewhere in the middle, you know, then it might be considered an offer in compromise, but weren't they required to establish what you paid versus what they were demanding? That's the crux of the case.
Even if the EOBs would establish what we paid, we still have to get to, does that establish the reasonable necessity of the services? That was one of the main issues is that, they said, well, MEMIC must have concluded they were reasonable or they wouldn't have paid anything, but that's not the standard. I mean, the standard is, I'm sorry, I lost my train of thought there for a minute.
It's okay.
Yeah. The standard is essentially that, we moved in limine before trial. We renewed the objection during trial and there was nothing offered, no proper purpose for these payments. These payments were offered for the purpose of establishing liability.
Okay.
Wasn't it in part shown though to introduce saying, look, this suit was brought because we charged, $100 and defendant only paid 45. That's why we have this suit, not that
But
there's
and
some
they
sort of
they could have
evidence of
brought that in through the
compromise.
testimony of the, they had the owner testify about the rates and everything. They didn't need to bring in this EOB documentation. It's an offer of compromise. There's case law to the effect that if you're bringing it in to establish that the services were reasonable, it's.
Yeah, I just can't buy that. I mean, it's not a settlement offer. It's what triggered the lawsuit.
Right.
So if
Right, and
we then entered into a negotiation, that's what the rule is designed to prevent, a jury or the finder of fact from hearing, oh, well, the defendant offered us this much money to settle this case. They must think they're liable to
Right.
some degree. We don't want that going before
Right.
the finder
Okay,
of
so our,
fact. That's
I
not
guess
what happened here.
my position would be even if this EOB documentation was admissible to establish the contract dispute, they charged this, we only paid this. Still doesn't establish the reasonable necessity of the services. There was no admissible evidence to establish that. And so that would be our position in favor of the support of a remand for denial of the motion for directed verdict.
Directive verdict, yeah.
Yes. And if you have any other questions, otherwise I can hand it over on the attorney fees.
Okay, and then you do have a cross appeal, right?
Well,
And you'll,
It's their appeal, yeah, on the attorney's fees issue.
oh, okay.
It's not.
I just want to have one
Sure.
question just to clarify. Are you abandoning your argument that there is no direct standing to recover the unpaid attendant care in
I'm
light of the
acknowledging-
Centria case?
I'm acknowledging that the Supreme Court overturned the Century case on which I relied, yes.
Okay. Would you acknowledge that it would have been good course to provide that to the court prior
The
to
other
plaintiff?
party did, so.
Okay. All right, any other questions? Okay. And we will do, it's Mr. Granzato's cross appeal, so you'll get a chance to respond to that during your rebuttal time.
Thank you, your honors.
I assume you know about the Centria
Yes.
decision by the
Yes.
Supreme Court. So moving on to the directed verdict, I think it's very important to understand that the defendant is operating under a serious misapprehension of how directed verdicts work. It's very important, it seems to me, to understand that when a directed verdict is made, the trial judge is to look at all the evidence presented during the course of the case up to that point. In fact, the defendant in their brief has the correct standard for a directed verdict motion is found on page 8 of their brief. The court, the circuit court, reviews the evidence presented up to that time of the motion to determine whether the evidence created a factual issue on which reasonable minds could differ. That's the reason this is very important in this situation is because the defendant is suggesting to you that you can review a trial court's a trial presented to the trial court. You can subtract the evidence that was, in their opinion, improperly admitted. And on the basis of the difference, I guess that's the subtraction term that would be used, assess whether there should be a directed verdict. That's not the way the process works. Okay, it's very important to understand this. There's a Michigan Supreme Court case, which is very enlightening on this subject. It's called Tennyson. It's actually an order at 469 Mich 1021, because what happened in Tennyson is that the plaintiff submitted a deposition at the trial, The defendant on appeal to this court said that deposition should not have been admitted, subtracted from the sum total of the evidence presented, and on that basis, issue a directed verdict. This court agreed and it directed a verdict. It went to the Supreme Court and the Supreme Court said that's not the way the process works. And that's not the way the process works here, because the trial judge is bound to assess in a directed verdict motion all of the evidence presented, whether it was improperly admitted or not. Because what the Supreme Court ended up saying in Tennyson is that on determining that the trial deposition of plaintiff's decedent was improperly admitted, the appropriate remedy was not entry of judgment for the defendant, but rather a new trial at which the plaintiff could seek to offer other evidence. In other words, when you have improperly admitted evidence, okay, you do not subtract that improperly admitted evidence and issue either a directed verdict or a J&OB. The appropriate appellate remedy is a new trial. And what's very important about this case, the defendant has not requested a new trial. And because of that fact, the only issue in front of you is whether there was any evidence, as you know the standard for directed verdict. The standard is you have to construe all of the evidence in the light most favorable to the non-moving party, and you have to determine whether there was any evidence to support the verdict. Now, you don't have to address any of these issues that the defendant has raised in this appeal regarding evidence because, and a very important reason, they haven't requested a new trial. All they are saying is that they should get a directed verdict. Well, a directed verdict requires you to construe the evidence presented in the light most favorable to the plaintiff. And the most important thing for our purposes here today is that they completely ignore their own testimony, the testimony of their two agents who testified in this case about, and by the way, they were both part of the plaintiff's case in chief, importantly, because that means they were in evidence, their testimony was in evidence before the directed verdict was made. And Mr. Foltz, one of their corporate designee for purposes of this case. And so he was asked if we've gotten to this point where these payments are made, the adjuster would have needed to establish contract, injury in an accident, injuries related to the accident, and necessity for such services, correct? Mr. Foltz says yes. And Ms. Horton, the second of the defendant's agents who testified, went through a series of questions about what it meant to pay, to make these payments. Did it mean that there was an accident? Did it mean that there was a contract? Did it mean that the insured was injured in the accident? And she said, yes, yes, yes to all of those things. And then she said, thank you. So from Mimic's perspective, the only issue at this trial is whether or not a reasonable rate was paid to my client for the services it provided, correct? Answer, yes. Now, they want a directed verdict. They, on the basis of evidentiary issues. Okay, they can't get it because, and you don't even have to reach these questions of this admissibility of the evidence. Why? Because on the basis of the testimony of their own agents, the one thing, of course, they didn't concede was reasonableness, but that was Ms. Delgado, who testified at length about the reasonableness of the charges. So they're sort of missing the whole point of the directed verdict standard. The question you face is, was there any evidence to support the jury's verdict?
I think we get it, Mr. Granzato.
Okay.
Unless you have anything else on your
go on for
response,
hours, but
anything else, anything on the attorney fees? then-
Yeah, let's talk
Yeah.
about attorney fees, because
Right.
that is by far a more serious issue here. Okay. Obviously, what's important about this case is Ms. Horton, the adjuster, but she, and most important for purposes of the the attorney fees issue, she was the post litigation adjuster. Okay, she testified at trial as to tried to justify the rates that were paid. Okay, the thing that was at issue, the difference obviously between what they paid and what the plaintiff was requesting in the case. Ms. Horton testified to that. Okay, but importantly, she wasn't there at the time the decision was made.
Why does that matter? I mean,
We-
we know that what they paid, obviously, and she testified to what Mimic had
Yeah.
paid the previous provider, which were roughly, equal to one another. So
Yes.
that's all admissible, it seems to me. Why do we need to have the person there at the trial who actually made the decision at that time about what to
I
pay your
think
client?
under Brown, the case we've cited to the court, and there are others as well, if you're interested. It is an essential point because remember, the jury did find that there was undue delay in paying. And when under 3142, it made the determination and assessed penalty interest. So that prong of the attorney fee provision was satisfied. But what Brown says to me is very important in this respect. The court has to examine the circumstances as they existed at the time the insurer made the decision to do what they did that the plaintiff is challenging. In this case, underpaying from the plaintiff's perspective. Okay.
But can a representative be offered to testify to those circumstances, even though that individual, in their kind of representative capacity on behalf of the institution?
Yes, but the point is, when Ms. Horton testified at trial, she made no attempt to do this. What she testified to was that after the fact, after she got involved and the litigation had begun, she made a few phone calls or did whatever and got a determination that Mimic had paid one party slightly less. Okay. That's all she did. But Brown says,
Why isn't that enough for the court to have concluded that made the decision not unreasonable?
well, I think Brown has pegged the decision temporally. That Brown requires that there be some determination at the time the decision is made. And there is no question that Ms. Horton couldn't and didn't. I mean, it's obviously a question of unreasonable decision to deny payment. There was sort of a 45% reduction, which may have been something to do with a misconstruction of the 2019 changes to the No-Fault Act, whether that's true or not, but we don't know. And we don't know because nobody ever provided it. They had an opportunity at trial, and Ms. Horton did not testify to that. She testified to her own determination. And Brown makes sense, doesn't it? Brown says if you're going to be unreasonable in either denying or delaying, you got to look to the time they made the decision. Okay, and they had an opportunity when the motion was filed post trial.
But getting to Judge Mariani's point, the testimony, your position is it has to come from somebody who existed or was alive at that time and looked at the things at that time. It can't be a corporate rep who looks back at it and explains to the jury and the judge, here's why it's reasonable.
My guess is that's why there are hundreds and hundreds of pages of these claims files. Okay, people make notes, people determine, put down in writing what they did and why they did it. Okay, I mean, there's got to be some justification at the time. That's what Brown says. And that was what's completely missing. And again, as we've pointed out, there is, once you have this undue delay under 3142, and the jury obviously decided that, there is a rebuttable presumption that there was improper delay. That's part of Brown as well. And it's got to be rebutted. There's got to be affirmative evidence rebutting that fact. And it didn't come. And that's why this is appropriate. I mean, I really do think the temporal thing is very important in this context. You've got to justify what you did, okay? Because there was a delay in the proper payment.
Any other questions for Mr. Granzato?
Thank you.
Thank you very much. Ms. Peck, you can make your rebuttal argument on your appeal and then respond to the attorney fees.
Yes, on the merits, I will rest on my briefs primarily. I do believe that, I'm sorry, I was gonna address one point he made. Yes, in terms of the improper denial or the improper bringing of a motion for directed verdict, we cite a case law that we challenged these decisions in a motion in limine, preserved them for review, brought the motion for directed verdict properly at the close of proofs. The motion for directed verdict was proper. On the attorney fees issue, let's see here. I want to just, no, I don't want the court to overlook the fact that we are contesting jurisdiction on this issue because of the untimely claim of appeal. I cited all the court rules and the case law, so I'll rest on my briefs on that part, but the claim of appeal is untimely and the court does lack jurisdiction over this appeal. If the court does consider it, I just want to remind the court also that this is clear error, highly deferential to the trial court. There's no problems in the admissibility of the testimony of our claims representative. She had access to the file. There was no dispute as to what MEMIC previously paid. There was no dispute as to what MEMIC paid this Relvar. I mean, it's not speculative as they say in their brief. And the trial court was well within its discretion to find that the disparity in the amounts was a bona fide uncertainty as the reasonableness of the charges. Again, the issue is not whether those charges were actually reasonable. It's did MEMIC have a bona fide uncertainty, and the fact that they were paying quite a bit less to the previous provider who was providing the same services to the same patient during the same general time frame creates a bona fide uncertainty and precludes the assessment of attorney fees and penalty interest.
Any questions? All right, thank you. Mr. Granzato, any rebuttal on the attorney fee issue?
Just to let you know, MCR 7.204A specifically states that you have 21 days to file a claim of appeal, either from the entry of the order or the entry on the docket sheet. Okay, it's something a lot of people, you know it, but a lot of people don't know. And the fact is, I think the defendant doesn't know, but it was entered on the docket sheet much later than it was signed by the judge. I think that's because it was a visiting judge, but.
Okay, that wasn't rebuttal on your cross appeal, but I let you get away with it.
No.
Okay. All right, thank you very much. The case is submitted. We appreciate your arguments today. That brings us to the last case on our 10 a.m. case call, item 6, docket number 371812. Estate of Muhammad A. Sadek versus Jeffrey Lee Harvey.
Good morning, Your Honors. Ellen Schrader for the plaintiff. This case was decided in Oakland Circuit Court on the basis of a motion for summary disposition in lieu of answer. There was no discovery in this Oakland Circuit Court case before this motion for summary disposition was granted. And Michigan law is generally a grant of summary disposition is premature before discovery on a disputed issue. Here, a 40-year-old gentleman was driving on his way to work in Lansing. The expressway was down to one lane by concrete barriers. He was trying to get over, and a semi-truck was driving in the right lane. And the video, I hope you've had an opportunity to see the video. The entire time of the video, he has his visors down at least 2/3 of the way of the windshield. And he's talking on the phone, not paying any attention. It's clear in the video. And we addressed this to the trial court, and the trial court focused on the fact that the expert affidavit said that the cameras were disabled. But the expert affidavit also said that The defendant's visors were tilted fully down, eliminating much of his view through the windshield. Defendant was driving improperly while distracted. Defendant driver should have seen that the car was approaching in the left lane. He easily could have hit the brakes, but he never hit the brakes before the collision. He was required to regularly and frequently check his mirrors, which obviously he didn't, and he never attempted to brake. In this case, the motion was based on 2.116C8, which should only check the adequacy of the pleadings. Never was anything in the plaintiff's complaint criticized by the trial judge. He focused on factual issues, and he focused on the disabling of the cameras versus the distraction of the driver. There were no inadequacies in plaintiff's complaint, and we should have been allowed to have discovery, to take depositions of the driver and find out matters in discovery before any motion for summary judgment should have been granted. In addition, the judge was making factual determinations not based on any testimony. The plaintiff's claim could have been successful on economic damages, even if the plaintiff was more than 50% at fault. So it's our request that we be allowed to return to the trial court and have discovery in this matter before a summary disposition of all facts.
You think, was this a C10 or a C8 ultimately?
It was written as C8 and C10.
Okay.
And so C10, we think those factual questions of cause and the statutory violations and the comparative fault are all questions of fact.
It appears to me that the court granted it on the basis of C10 because it considered evidence outside the pleadings, and yet no discovery had taken place at this point, right?
Correct.
Okay.
And at the time, just to be clear, the video you referenced, was that provided to the trial court in response to the motion for
Yes.
summary disposition?
Yes, twice, and with the motion for reconsideration. And there's no indication that it was ever viewed or considered. I hope that we've submitted 5 copies to the Court of Appeals, so I hope that that video was considered as well.
All right. Any other questions for counsel? Okay, you'll have time for rebuttal.
Morning, Your Honors. David Shiner on behalf of the defendants appellees. To your point, Judge Godola, we acknowledge in our brief that, yes, this motion was initially filed pursuant to MCR 2.116C8 and 10. But with all the evidence and the documents that the trial court considered and based its decision to grant summary disposition on, we acknowledge that this was a decision based on MCR 2.116C10. To address one point that was just made as far as the availability of economic damages, I think what plaintiff is overlooking is that this is a case that was filed pursuant to MCR 2.11. MCL 500-3135, and specifically under the 3135-2B, it provides an additional limitation than is under MCL 600-2959 that precludes the recovery of non-economic damages in the event that the plaintiff is more than 50% at fault, but still allows economic damages. But MCL 500-3135-2B provides that additional limitation that no damages must be awarded in the event that the plaintiff or the claimant is more than 50% at fault. So I think that's just something that's overlooked when considering that is a complete preclusion of the claim.
How can the judge make that determination when it appears there are, and we've had no discovery on these questions of, was the driver of the truck talking on the phone at the time of the accident? How fast was the driver of the truck going? Did he apply the brakes? Did he observe this car in the left-hand lane as it passed him and attempted to merge? We've had no discovery on all of those allegations. So how could the judge at that point make a determination that plaintiff was more than 50% at fault?
Well, considering, and I think another thing that needs to be addressed, I think the idea that no discovery was conducted is a little bit of That's not necessarily-
Overstatement? Is that?
Or it's not really what happened. And in that, on that point, the plaintiff's attorney, in connection with the underlying probate matter, sent subpoenas out. There were FOIA requests for a pretty extensive law enforcement, the investigation files from the law enforcement investigating agencies. That included the vehicle data from the decedent's vehicle. Plaintiff had the opportunity to subpoena in connection with that probate matter information, those videos that were obtained from Hunter Express, the defendant. And so, you know, I guess it is technically correct that discovery didn't commence, but discovery is just the discovery of documents, the ability to obtain documents. Plaintiff had that opportunity. Plaintiff presented all that they had obtained and said, wait a minute, there's a question of fact here. Now, what is also overlooked is the facts that are established by that evidence. The facts that are established by that evidence was that the decedent reached almost 2.25 seconds before the actual collision, was driving 90 miles an hour in the left lane in an active construction zone, attempted to cut off Mr. Harvey's vehicle, made contact with the side of the vehicle, and unfortunately the collision occurred that way. So as far as the concept of, or the idea that no discovery had taken place and that the decision to grant summary disposition might have been premature, the question is really whether any additional discovery.
Well, was to that point, was the semi driver's deposition taken in this case?
It was not, but I mean, when we're considering, was the plaintiff more than 50% at fault? And now considering the information and the data that we do have, how can a reasonable juror come to a conclusion that a driver driving 90 miles an hour trying to cut off a semi truck in an active construction zone and collides with, rams into essentially the semi truck, how is that driver not more than, or any less than 50% at fault? And I think that's the question there. So the question on prematurity and the lack of discovery in this case, the information that we do have paints a very clear picture of the whole events of the accident and what discovery is going to change that. We have exactly what happened, the motion of the vehicles, the speed of the vehicles. We're talking about a 60-mile-an-hour zone, and he reaches almost.
You know what happened a quarter mile before that accident?
We don't.
Could that be relevant to what happened a quarter mile down the road?
Not as far as the actual occurrence of the accident.
Yeah. Aren't there facts that could have precipitated the last 5 seconds of that accident that would be relevant to whose fault it was? If the semi had slowed and then when he tried to get in, all of a sudden started to accelerate to effectively block him, isn't that in part why discovery is needed? To Judge Godola's point, testimony about what occurred just before that last 5 seconds, what was the driver doing?
Well, when if we take the 5 seconds at least, which is it's a substantial amount of time when you're talking about, you know, on the road and distances and everything, this vehicle was traveling between 85 and 90, almost 90 miles an hour. And
I guess my point is, when would you, I mean, with today's technology, then when would you ever need testimony? You just take the data that comes from the cars and the police report, you know, testimony be damned. I mean, that's a standard you're sort of suggesting. You're saying, I've got car data and I've got police reports that I got, but what else do I need?
We all know that people do unpredictable things on the Lodge Freeway, for example, right over here somewhere. Doesn't the question become at a certain point what a driver does in response to an unpredictable action by another driver? Isn't that something trier of fact ought to know?
Well, and if we're talking about what a reasonable driver would do, and something also discussed in our brief here, in our brief was the right of way and to the extent that the plaintiff or the decedent driving 90 miles an hour had some right of way to be able to merge into that lane. He lost that right of way when he was driving at one point, almost 28 or more than 28 miles an hour over the speed limit. So the question is negligence, and what would a reasonable driver do in Mr. Harvey's position? Was he supposed to take action to avoid getting rammed into by a car driving at
maybe.
point of impact?
When you see him there, hit the brakes, or notice that he's coming up trying to pass you in the first instance. I mean, we just don't know. No discovery. As you confirmed for me, his deposition was not taken.
No, it was not. And I guess to the point about what facts or what discovery were considered, there were statements of witnesses, now understanding whatever value those have. There were statements of witnesses detailed in the police investigation materials. And I think one of the quotes from one of the witnesses was the driver of the truck didn't do anything wrong. So when the standard becomes, is discovery, does it stand a fair chance of uncovering facts that will support the plaintiff's position? This is not that case when we're talking about what has been established as far as at least the actions of the decedent, and when considering that the question, as far as his actions go, is, was he more than 50% at fault here? So with that said, I don't think discovery or summary disposition was not prematurely granted, where the plaintiff had opportunity to collect evidence, presented it, relied on it, retained an expert that relied on it, and presented that expert as saying, here's the question of fact, and the court disagreed. The trial court said him having his visors down, that may have obstructed, and that's another point that the plaintiff is relying on, that the visors were down, it may have somehow obstructed his front view. We're talking about a car approaching the left rear of the vehicle at 90 miles an hour and essentially ramming into him. So if that's the allegation of negligence here, the trial court correctly concluded that summary disposition was appropriate, and we would request that that decision be affirmed.
Okay, thank you. Any rebuttal, counsel?
Let me reiterate what has already been said, that subpoenas of records is not the same as testimony. The driver, this individual driver, had a perfectly clean record. He's faced with a choice of driving into a cement wall or trying to speed in front of this huge semi truck. And the semi truck was completely ignoring him and couldn't even see out of his windshield and never looked in his side mirror. So we would ask that you return this to the trial court so that discovery may begin.
All right, any other questions? Very good, thank you.
Thank you.
Case is submitted. That brings us to the conclusion of our 10 a.m. call. It's 10 afternoon. We'll take a brief recess and pick up with our 11 a.m. case call. Very brief. Thank you very much. All right. Welcome again. For those of you who weren't here at the outset, this is panel 2 in Detroit. We're about to commence the 11 a.m. portion of our case call. We have read your briefs. We've had reports from our staff. You don't need to belabor the facts. Just let us know succinctly why you think you should prevail in your appeal today. With minor children, please no proper names, just initials. Okay, with that, item 7, docket number 371906, Jacob Abraham versus Hesham Gayar.
Good afternoon, Your Honors. Daniel Schuman appearing on behalf of the appellants in this matter. It's the appellant's position that they got far from a fair shake at the arbitration hearing. We're not attempting to make arguments that a court should review and overturn factual determinations by an arbitrator. What we're saying is that this arbitrator was so far off base that he made He pulled factual determinations out of thin air and then put that down as what this ruling was.
Okay, you just said two things that conflict with one another. You don't want us to judge the facts, but the error here is that the arbitrator messed up on the factual determinations. So which is it?
I guess what I'm trying to very poorly represent to this court
No,
is that there's a difference between a factual determination and something that is just conjured out of thin air called a fact.
okay.
And our position is if the arbitrator hasn't listened to the testimony and simply makes statements that are wholly wrong and is not supported by any testimony, any briefing of any nature, that is grounds to vacate, because that's not only misconduct, but it's gone above and beyond what the arbitrator.
Am I remembering correctly? This is a case where we don't have a transcript of the arbitration proceeding.
No, we do.
Oh, we do? Okay.
Absolutely, we do.
Different case,
So
maybe tomorrow.
This is
Okay.
the case where the arbitrator starts off by confusing who the petitioner and the respondents are.
Okay.
Completely, I mean, that wasn't a good start for my client to see that, or me to see that, you know, after 4 days of arbitration, the arbitrator who's supposed to give a reasoned opinion confuses who the petitioner and the respondent are.
How was the arbitrator selected? What was the process?
Well, after quite a bit of going back and forth, we mutually, appellee's counsel and I mutually agreed
So
to
you-
use this arbitrator. It was our choice.
Okay.
Agreed upon choice. Was not our first choice, but with everything that came to play, this is how it ended up. So what I really just like, because I understand you've read the briefs and everything, to focus on is that there is one key fact that Ms. Fossey and I and all the parties agree upon, that the arbitrator was way off base, had nothing to do with evidence that was presented, and just conjured this up out of thin air. And that is when the arbitrator said the purpose of establishing my client's company was for federal and state tax law, and that there were no rights automatically accrued as to a member. It was never even discussed anything about taxes. This is so out of the blue that it's shocking. And that's why I believe it raises to the standard that this should be vacated. But if you follow up on that, why I believe that is material and is of the utmost importance is we have an oppression claim before the arbitrator. It's our position that my client was removed from a company with a secret vote at a secret meeting, and then the remaining members divvied up his share and just started a new company and opened the dispensary. So that goes to the heart of this. If the arbitrator is wrongfully out of thin air come up with the idea that these members of a Michigan LLC with an operating agreement have zero rights, then he has no rights not to be oppressed. So when the arbitrator erroneously makes the determination that, hey, despite this being a Michigan LLC formed in Lansing, et cetera, bound by the LLC Act, in addition to that, they have an operating agreement, but they have no rights. How are you going to win an oppression arbitration when it's already predetermined without actual any evidence of any nature that, you know, the person certainly, you know, if you have no rights, you can't be oppressed. So every other ruling that he made was based upon this erroneous, agreed upon erroneous determination that the company was just set up for a tax shelter and these guys had no rights. Once he said that, which is completely wrong and off base, our position is we have a right to, we should be allowed to vacate that ruling because it's so far off base. It is not based on any evidence that was presented, that it's well beyond what the arbitrator agreed to do, follow the law and base it upon the evidence presented. I don't think you're going to hear any dispute from Ms. Fossey. She said it right in her brief that this finding is factually incorrect. It wasn't there. And this isn't the only thing in here. I've gone through it. I'm not going to belabor all of these points, but he determined that the landlord was the owner and the licensee of this dispensary. And every single witness that had any knowledge of that subject said completely to the contrary. Ms. Fosse's brief, my brief was all to the contrary of that. It just makes zero sense. He obviously, well, I shouldn't say that. It would appear to the appellants that he obviously wasn't paying any attention to anything that was presented. He did not review the transcripts. He simply made his own determinations and conjured it out of thin air. And when you have an arbitrator that does that, you do not have a true arbitration. It's to the point where I would call it some sort of due process violation. We spend all this time, we spend all this money, we present our arguments, and the arbitrator comes back with things that are so far off the wall that both sides agree that it just never happened. So that's our position. That's why we're here in front of you today. And that's why we're asking that the matter be vacated and that we get a fair shot at an arbitration with the new arbitrator.
Any questions? All right, you'll have time for a rebuttal.
Thank you very much.
I'm going to prop myself up so that I can be seen.
Yes, come prepared.
Speaking of thin air, Mr. Schuman has raised this argument for the first time.
Give us your appearance, counsel.
Oh, I'm Carol Fosse on behalf of defendants.
Very good.
Thank you. I apologize.
No problem.
But the appellant is making now an argument which I've never heard before. Certainly, this business about the company being formed for tax purposes was not relevant to any finding of the arbitrator. He made a mistake, but it was not out of thin air. There was in fact testimony that the successor company, HTP, was created for tax purposes. So the arbitrator mixed up HTP and TEL 12, but it was not completely out of thin air. More importantly, Mr. Schuman is telling us that that the court should review findings of fact of the arbitrator, that Judge Warren got it wrong when he refused to consider the findings of fact of the arbitrator. And in fact, in the motion to vacate, the findings of fact of the arbitrator, which the appellants now challenge, are different from the ones they presented to Judge Warren in the motion to vacate. So it seems as if this argument is being made in order to have somebody re-review the findings of fact of the arbitrator. In fact, the arbitrator had evidence to support all of the findings that he made. He made extraneous findings as well, but the findings with respect to misrepresentation and with respect to oppression were replete in the evidence. In particular, the arbitrator found that with respect to misrepresentation, that it wasn't until a year and a half after the presumed representations were made that the defendants had any thought of changing their intentions. And the arbitrator had listened to the testimony of the three individual defendants, Hasham Gayar, Tarek Gayar, and Paul Lutfi. Each of them testified that they didn't even think of changing their intention for a year and a half after the alleged oral representations. And in fact, before they ever signed the written operating agreement. The other thing that the arbitrator found, and this is with respect to the oppression claim, is that as Judge Grant had ruled, subsection 2.09 of the operating agreement permitted all of the actions which appellants challenged. So that when he says, I wasn't fairly treated, they were in the operating agreement that he signed and which he had presented to his counsel before he signed it. I have nothing else to say because this is all question of fact, which is not even reviewable, and you all know that.
Any questions for counsel? All right, thank you very much. Any rebuttal, counsel?
Unless there's questions.
Any further questions? All right, very good. Thank you both for appearing here today. We appreciate your arguments and the case is submitted. That takes us to item number 8. Docket number 370813, City of Wayne versus Anthony Wayne Miller.
Good afternoon.
Afternoon.
Good afternoon, Your Honors. Nathan Petrusek on behalf of Appellant City of Wayne. The facts of this case are well documented in our brief. I'm not going to belabor them except to say that the city filed a complaint against a former city council member for his disclosure of a attorney-client privilege report. The city responded to that by filing a complaint against him in the circuit court for breach of fiduciary duty for disclosing that attorney-client information. The trial court granted summary disposition of the city's claim in favor of the appellee. The city is not challenging that on appeal. I think in large part it wishes to be done with the matter. What it is challenging is the lower court's determination that its complaint was frivolous and the assessment of in excess of $71,000 in sanctions against them representing attorney fees and costs and the awarding of a $1,500 an hour attorney rate. The finding of frivolousness dovetails with the reasons for the granting of summary disposition, so we'll touch on it briefly. The court essentially found that the city's claim was frivolous for 2 reasons. First, it found that the claim was barred by a 3-year statute of limitations, which was simply incorrect. There were a couple of dates at issue. There was an August 4th, 2018 workplace report that was issued, which was followed by an August 14th closed session, which was then followed by an August 20th special supplemental report, and then a September 4th, 2018 city council meeting at which the city council voted to release the August 4th workplace evaluation, but not the August 20th supplemental report. In finding that the claim was barred by a 3-year statute of limitations, the court essentially found that the claim began to run as of September 4th, 2018, the date of the city council meeting at which the supplemental report was not voted on to be released, instead of the date of June 17th, 2019, which is the date that appellee Miller actually disclosed the attorney-client privilege report to the Michigan State Police. If you bump the date forward to the June 17th disclosure date, the filing of the complaint was well within the 3-year statute of limitations. The second finding in support of frivolousness by the lower court was that the city should have known, or rather that the city had waived its attorney-client privilege. In reliance on that finding, it relied upon a United States District Court opinion from Judge Kumar from September of 2022, that finding that the attorney-client privilege had been subsequently waived following the September meeting because the following day, both reports were posted on the internet for about 15 minutes before they were taken down. Our contention is, and I think the law supports, that it was an error for the court to make the determination that the city didn't have a reasonable belief in the legal arguments supporting its claims or the facts when the federal court opinion relied on federal privilege law. It did not rely on Michigan privilege law, which of course requires a true waiver. There was no evidence in the lower court case that there was any kind of true waiver. There's no evidence that 15 minutes of posting online by an unknown individual for an unknown reason before being yanked off the internet because of realizing the second report was posted when it was not supposed to be, constitutes a true waiver of the attorney-client
Essentially
privilege.
an intent requirement in the state law, right?
Exactly right, Your Honor. And there was no.
Be considered an inadvertent waiver at best.
It would have been an inadvertent waiver at best, which is not enough. And there weren't any facts to support any intentional waiving of the attorney-client privilege just by virtue of that posting. So our belief is, and our argument is, that the lower court should not have determined that the complaint was frivolous at all and should not have sanctioned the city of Wayne at all. But moving on from that point, even if there was grounds to find that the complaint was frivolous, there was no basis to award $71,000 in sanctions at an hourly rate of $1,500 an hour to appellee's counsel. It kind of goes without saying. There was no evidence at the evidentiary hearing of what Mr. Razor actually was charging Mr. Miller at all in terms of an hourly rate, what his fee agreement was in the case. The $1,500 an hour rate is more than the 95th percentile for civil litigation in 2023. It was double the amount of civil rights litigation for 2023, which was $710, and was a full $300 more than the 95th percentile rate, even for medical malpractice actions in 2023. And this, of course, was a breach of fiduciary duty claim having nothing to do with medical malpractice. It was entirely unwarranted for the court to conclude that simply because an attorney who used to work for Mr. Razor, who is admittedly a very good attorney, was awarded those attorney fees in an entirely separate medical malpractice case, that Mr. Razor should then be afforded the exact same $1,500 rate. It essentially amounts to an award of punitive damages against the city, which is barred by the court rules. And with that, unless the panel has any other questions.
Any others? All right, you'll have time for a vote.
Thank you, Your Honors.
Thank you, counsel.
Good afternoon.
Good afternoon.
Attorney Jim Razor on behalf of former Councilman Miller, along with my colleague attorney Amanda Washburn, and our law clerk Sean Cotton is present in the courtroom. I believe that modesty is a virtue, but this might not be the best case to espouse that virtue. Let's talk first, though, about the frivolity. This was a slap case from a city that had sued at least one other city councilman who was forced to resign. There were a number of other suits, including Judge Selena Kumar's case up in Flint, where she looked at the report. The judge did a very careful job, as reflected in the transcripts, of granting the summary disposition motion, establishing frivolity, going through the factors for attorney fees, and came up with the right result. So let me clarify something. In reading the briefing from the city, there's this specter that like somebody released this report. We don't know who, it's just somebody. Well, the fact is that Ms. Gable testified it was available on the city website. There's no affidavit from anybody from the city saying we put it there by mistake.
Well, what are we to take from the fact that they took it down 15 minutes later? What can we infer from that?
Well, first of all, there's no testimony that it was only up for 15 minutes. That's just something they made up in their brief. We don't know how long it was up. We do know it was taken down. But here's the interesting part about that. Both the initial report and the supplement were taken down. That's inconsistent with the city's argument that the original report was allowed to be posted, right? They say that even though the court watched the entire video of the September 4th, 2018 hearing and is entitled to great deference of her decisions based on that, they say even though she watched the entire video, and even though my client said, Madam Mayor, I would like to include that this will also contain the follow-up sub-report to the investigation, to which the mayor responded, thank you. And the mayor indicated she would rather have the report out in its entirety. And the mayor explicitly stated, I will put out what we have received. And again, they had received both the original report and the supplement by this date. And the court concluded that that action, after watching that video, constituted a knowing and intentional waiver of privilege.
Now, counsel, you would agree as a former councilman that the holder of the waiver is the council in its entirety. Is that correct?
The holder of the privilege, yes, is the entity, is the municipality.
And they act through resolution of their council.
Yes.
And then the resolution would be evidence of what they voted on, would be the best evidence of what they voted on versus this talking over each other in a public meeting.
I think you have to look at the video, and I can tell you.
Isn't the vote controlled by what is written in the resolution, not the video and not the discussion of the members? There's lots of discussion, as you know, as a former city councilman. there's lots of discussion that happens, but what is written in that resolution is what controls what is released. Isn't
I think
that
it's
correct?
very important. I think it's very important. The minutes are very important. Royal Oak, when I was commissioner, they first used to write everything down, and now they just rely on the video. And I'm pretty sure that Wayne does that as well, is they rely on the video.
But
as
under the
minutes
Open
of
Meetings
meeting.
Act, you have the city, public bodies have to reduce their meeting minutes and then they have to be approved at the next meeting.
All true, and I don't disagree. But the question here is whether it was an accident as to whether the report and the supplement wound up on the website, right?
But I don't see anything in that video or in the resolution where the council said release both the original and the supplemental and put them up on the city website. I mean, that's what would be required to assume that it was a knowing and intentional waiver to put it on a website. Isn't that what would isn't that the standard we have to look at, the lens we have to look at these facts through?
Well, I think you have to look at the trial court's determination and give it deference. And based on her determination and the mayor saying we're putting out on its entirety, and the fact that it was on its city website the next day. But Judge Shrellicott, let's go down the road that you're taking me, which is the resolution only released the original report. I think that's the road you're taking me down. So let's say that's the fact. Why was the original report taken from the website after it was intentionally put up? That's the problem. The problem is
because it was inadvertently put up. I think that's what my initial question suggested in terms of what inference we can draw from that fact.
well, I think the city, through its council, meant to remove attorney-client privilege from the report and the addendum. Cities do that by putting things on their website and allowing them to be downloaded by the public. Ms. Gable, a member of the public, downloaded the report and the supplement from the city website. We don't know how long it was on the city website. You will see no evidence that it was there for 15 minutes. You'll see no evidence from the city that so-and-so testified that it was a mistake to put it up and 15 minutes later I put it down. That's the problem that I'm having with their argument that it was an accident. I can tell you, I've represented the city of Royal Oak since I've been a commissioner, and the first thing I would have had is the IT person saying, I'm sorry, I screwed up. That wasn't supposed to be there. That's why I jerked it down. It went on at this time. It went off on this time. There's no evidence of that. They have zero evidence that it was inadvertent except for their say-so.
So, Mr. Razor, you'd like us to look at what was said verbally at the meeting. I think Judge Trebilcock correctly posits that the best evidence of what was done is the language of the resolution that was adopted, what was voted upon. But if we're going to look at what was said, don't we need to look at everything that was said?
Sure.
And I think he left out something pretty important that the mayor said at the meeting. She stated that it would, that the city would release, quote, exactly what the council received at that closed meeting on that Tuesday night. And that wouldn't have included the supplemental report because it didn't exist at that time of the closed meeting, correct?
I believe you're right.
Okay.
But she also said, I will put out there what we have received.
Right.
So I think you have to look at it in the totality of the circumstances like the trial judge did. There was a vote by the council to put out that report, to remove attorney-client privilege on the report. The only issue is whether the supplement was part of what the privilege was removed, right?
So let's say if you can concede that, and I'm not saying you do, but let's concede that there was a plausible argument waiver. They didn't intend the supplement. And then they brought the lawsuit, right? That the reasonable minds could differ what the meaning of the resolution or what city council intended to do. And then but then your client releases it and they bring the claim, the breach of duty claim, right? Let's assume that's the correct result. There's an issue about that. Are you still saying it's frivolous to bring it at that point? If reasonable minds could differ, whether or not there was a waiver or not, does that then void the frivolity finding?
I don't think so.
Okay, explain.
I don't think so. I think because it was already circulating, Judge Kumar's reasoning was essentially, it was already out in the public. It had already been disseminated to the public. And it wasn't under nefarious circumstances. I think.
But doesn't a city councilman, can't the city councilman owe, or woman, man or woman, city council person owe duties, fiduciary duties or otherwise to the city that go beyond just, well, it's already out in the public. Therefore, I can do anything with this information I know. Don't they have an independent duty?
No, I don't believe so. Let me tell you why I think that, Judge, and it's a good question. If something's discussed at closed session, you have a duty, a fiduciary duty that survives to not talk about it anywhere else. And part of the part of what I brought to this case was knowing what questions I could ask Tony Miller or not, because I couldn't talk about anything in closed session, right? But if something is out in the public domain, I think that absolutely you have, as an elected official, an obligation and a right to discuss it. And certainly with other authorities. I mean, he wasn't discussing it with Joe Blow. He swore out an affidavit in a federal case. He talked to the police.
But not if it remains privileged.
Yeah,
Well,
that's I was gonna just ask that
Okay,
question.
Judge, you're right. Not if it remains privileged, but here's the problem. Here's the missing link. If you look at the meeting on September 4th, 2018, and then you look at the fact that the city released both the report and the supplement on their website the next day, you have a chain of intent. You have the intent of what the commission, or the council rather, wanted to do, and you have the city, the authority, the municipality releasing those two documents, I think it was three actually, on their website the next morning. The defendant, plaintiff would have you say that, oh, somebody nefariously got a hold of it and released it, or Councilman Miller got a hold of it and released it. That's not what happened. What happened is the city put the documents up on the website the next morning. So if they say that's an accident, that's their burden. They say, oh, that was accidental. What evidence have they given you that that was an accidental publication that didn't comport with
Isn't the
what
best
they
evidence
voted
of
on?
that? They pulled it down almost immediately?
But there's no evidence of that. There's no evidence of that in the record. The evidence of that in the record is what they say, and some affidavits from some people on the council.
Well, aren't
after the
affidavits
fact.
evidence?
I think they're evidence, but they were like evidence after the fact. They were evidence of people that were not on a witness list. They were evidence that came out of nowhere. But the fact of the matter is, wouldn't you need an IT person to say that I wrongly put it up? Wouldn't you need to understand the chain of how it wound up on the website?
Well, doesn't that then get back to my original point of reasonable minds could differ, or at least there's different versions of what could be true. And if what they say is true, that would support their claims and therefore it wouldn't be frivolous. Now, if what you say is true, then it still may mean there's no liability, but it doesn't necessarily mean it's not frivolous.
Well,
or that it is frivolous.
If you look at it from the perspective of Judge Gibson, I think you have to defer to what she was hearing at the time on the summary disposition motion. And she didn't have any problems looking at that. And I think if I remember right, the affidavits were proposed as part of the sanctions motion and not as part of the MSD. If I'm remembering that right, I could be wrong. But the fact of the matter is, when the judge looked at the council meeting and the evidence and Miss Gable's evidence, give me 1 second. I think that it's important to look at what they say and when they say it. There's no person that says it was a mistake to put that up on the website who actually put it up on the website. What you have is a political battle, right? You've got a report which is highly toxic, of a highly toxic work environment that squarely blames the city manager and the city administration. What we learned was that although the council had voted to remove privilege from the entire series of documents because the public had all sorts of thoughts about what was in them and rumors were swirling, and because they were paid for with public money, that they voted to release them. And the next day, the city attorney and the city manager overruled them, overruled the council and said, we're taking these off the website.
All right. I think we understand your argument.
Okay.
Anything else for us? Just sort of-
Well, I think I need to argue about the attorney fee issue.
All right.
In all fairness, right?
How often do you get a $1,500 an hour attorney fee
A lot.
from your hourly clients?
Well, it depends on the representation. I mean, it really depends on the representation. It depends on what you bring. That, you know, for an hourly client to pay you is a lot, but on a contingency fee case, Attorney Amanda Washburn and I, fortunately, in many cases, receive way more than $1,500 an hour
Well,
on
that's
cases.
not what this is.
Well,
right?
it's not, but
Okay, so let's stick to this case.
sure.
You know, an hour, as Judge Trebilcock asked, hourly rate.
Well,
I'm not asking you to tell us what your hourly rate is even.
thank you.
What hourly rate did you pay attorneys when you were at city council at Royal Oak?
What hourly rate did the city commission in Royal Oak pay
To their
attorneys?
attorneys, outside counsel?
I don't know.
Did they ever pay over $1,000?
I don't know. The reason I don't know is that the city attorney handled paying outside attorneys who were defense attorneys. So I don't know. I never had that. We saw them in closed session, but only in terms of talking about a case. We talked about their aggregate fees, and I can't tell you about what the specifics were, but I always found that the attorneys that the city hired got paid an awful lot to not do a bunch. And we're always encouraging us to continue on with litigation, which I knew was like a bad move. And I was always the one saying, settle the case. But the attorneys were always like, no, we should try it. No, we should appeal it. Regardless. The fact of the matter is that the the plaintiff admits in their brief that it's not the hourly rate that the attorney charges as part of the inquiry. As a matter of fact, they, on page 18 of their brief, say, importantly, our Supreme Court has explained that the goal of awarding attorney fees is to reimburse a prevailing party for its reasonable attorney fee. It's not intended to replicate exactly the fee the attorney would earn through a private fee agreement. They admit that. So let's say former Councilman Miller was a good friend and I did it on, on the house. Let's say I count my hourly rate. The inquiry is a reasonable fee. Then you do the math and you figure out the hours charged times what a reasonable fee is, and then you can upwardly adjust it. And here comes the part where I'm not going to be very modest. I have a track record of multi-million-dollar verdicts. I have a lot of municipal experience. Mike Pitt says that I'm in the upper echelon of trial lawyers in the state of Michigan. Judge Gibson, who I've been in front of and won verdicts in front of, says I'm in the top echelon. And the question becomes, what's the top echelon worth in the state of Michigan? In a world where sports figures and broadcasters make millions of dollars a season, what are lawyers worth? And you have to look at the complexity of the matter. Now, the plaintiff says, oh, this isn't complex. There is nothing in the manual about what defense of a TRO against a former public elected official costs. I mean, it's a very oddball thing. And perhaps Tony could have hired a couple of lawyers, one who knows a lot about municipal law, one who knows a lot about civil rights law, one that knows a lot about SLAPP lawsuits and done the same thing. But I happen to know something about all three of those areas. So really it was economical to do $1,500 an hour when a couple more lawyers could have billed on the file. And I don't think the amount of hours that I charged on the file was, outrageous. It was 22 months of defending an individual of limited means against a multi-million-dollar public entity that was essentially filing a SLAPP suit against him to get him to stop talking about the toxic work environment at the city. It wasn't easy. It wasn't easy to uncover the right evidence. It wasn't easy to get the right evidence in the can, and it is worthy of a high fee. If you think the judge screwed up and she shouldn't have adjusted it that much higher, I mean, in all fairness, I haven't tried a case against any of you. And I've tried cases with her, not against her, but, in her courtroom. And so, she's allowed to use that knowledge. And also I would say, what it's based on is this verdict that Mr. Marco and Mr. Feiger got in front of Judge David Allen in the Noden opinion. There's no case law in the Noden opinion because it was settled and the appeal was dismissed. So it's good law. And I think David Allen wrote a great opinion. And I don't think that saying, oh, this is medical malpractice, so, that's inopposite. The fact is that this was a complicated piece of litigation at the intersection of a lot of practice areas. Also, some of the verdicts that I've won are medical malpractice cases. I'm fully competent of doing that sort of work, and it's the same skill set to get into a case and to bring the evidence. The fact of the matter that it was medical malpractice versus a very strange civil rights First Amendment municipal law case, I don't think is something that you can hang your hat on when the trial judge, who knows me, knows Mr. Pett, knows everything about this type of case and my litigation style, says that I was well worth it. And again, I'm being immodest, but and to go back to that argument on frivolousness, I think you got to look at the litigation conduct of the city of Wayne very carefully, of suing all of their former councilmen and employees, which creates an atmosphere that Judge Gibson was looking at in regards to this particular case.
But that isn't in the record or something we consider whether it's frivolous or not. We look at what's in this case and the merits of this complaint.
It's an interesting argument or thought, Judge Treblecock, that you can't look at the litigation conduct of a person in front of you as their intent of filing a suit. I don't know that I completely agree with that. If you had somebody in front of you as a circuit court judge that you knew filed 100 frivolous cases, and you had the 101th of them, the 101th. Doesn't sound like a $1,500 an hour lawyer.
Might need to knock a couple nickels off of that rate.
Well, also, but the thing also is she already gave us a haircut. We got 64% of what we asked for. So we'd be getting a double haircut by knocking some money off that rate. But I understand it's a lot. But in an area where you have the top echelon lawyers, I want you to think about, there's no factual dispute. They didn't bring anybody to say that I was just, an idiot and I didn't know what I was doing, even though I've been doing it for 35 years and I just stumbled into all these verdicts. So you have to think to yourself for the profession, because this will be the published case on this rate, right? People will be looking at this case. What are the upper echelon lawyers worth that win these big victories, these big verdicts? And this was a big deal. The city was suing him for money damages, not just equity, not just an injunction. They wanted money out of him. This was a big deal. So your case law on what a rate should be, what an upper echelon rate should be, is something that's important to the jurisprudence of this state.
Well, we could make it published if you'd like us to.
Well, only if it's good. Only if it's good for my side of the fee, right?
But maybe you're right. It is a novel
I think it's
issue.
important, and I think you got to reread Judge Allen, who I very much like and respect. He wrote a very good opinion on what rate should be awarded when when an opposing party screws up on their risk management. In the Noden case, they really screwed up on their risk management, and you cannot reward them with knocking down the plaintiff's fees to things that are unreasonable. I mean, if you look at the rate that they are suggesting for me, which is like, I don't know, $300 an hour or something like that, I haven't charged that in 20 years. It would be outrageous to think that you could get the kind of legal talent for that kind of money. I mean, in upper echelon lawyers, which, I'm sorry, that's what the court said, and that's what Mike Pitt says, so I don't have to say it, but I did.
Okay.
So what are you going to determine that rate?
We understand. We got it.
Thank you.
All right. Thank you. Counsel, rebuttal?
Thank you.
And you're probably going to go there first anyway, but what is the evidence in the record about the reports being uploaded to the website and then removed 15 minutes later?
That would be what, I'm sorry, Your Honor, that would be what is on video with Mr. Miller telling the Michigan State Police during his interview with the Michigan State Police. It's cited on On page 4 of our brief, it's time stamped at the 43 minutes and 7-second mark through the 43-minute and 10-second mark. And the video is as part of our appendices, and I believe the video has been provided in multiple
So
copies to the court.
defendant himself said it was removed from the website 15 minutes after the initial publication.
Correct.
Okay, thank you.
That was the first point I was going to raise. The second point I was going to raise is that it was mentioned, and you're absolutely right. City councils, boards, planning commissions, ZBAs, they speak through their meeting minutes. Lots of things get said in a meeting, but there's a body of law in Michigan, and you'll forgive me, I don't remember the case specifically, but that specifically says boards speak and commissions speak through their meeting minutes. That is what matters. In this particular case, if there was a motion made by Appellee Miller and seconded by by Webster, that was to resolve to approve waiving the privilege and confidential status and release of the workplace evaluation performed by Dispute Resolution Services PC. The workplace, if you look at our in our appendices, the August 8th report is specifically entitled Workplace Evaluation. That's why we while we blacked out the body of it to preserve privilege, we didn't black out the title of it. So you can see that is the workplace evaluation. If you look at the other report from August 20th, it is called Supplemental to the Internal Report of Findings, Recommendations, and Conclusions, dated August 8th, 2018. They were the motion that was made by Appellee Miller specifically referred to just the first workplace evaluation, and he received support on that motion. That's important because when Appellee Miller subsequently raises the issue in conversation about wanting the supplement to be added, what he doesn't receive when he says that is a support or a second. Robert's Rules of Order govern everybody's meetings, basically, in Michigan. If you're going to amend your primary motion, you have to receive support or second on that amendment. And if you don't receive it, then it doesn't become part of the main motion. So his request as part of that never became part of the motion that was approved. And that is substantiated by, again, as you pointed out, what was said by the other members of the city council, which was that you're going to get what we were given at the closed session, which couldn't have included that. And I will remind the court also that some months later, Appellee Miller also raised the issue at a city council meeting again about waiving privilege on that supplemental report, which of course undercuts any idea that it would have been included the first time around. All of this is to say that the city had a good faith, reasonable belief that its attorney-client privilege had not been waived at all as to the supplemental report, that Mr. Miller violated or breached his fiduciary duties to the city to keep that information confidential when he went and disclosed it not just to MSP. He told MSP that he gave it to congresspeople, the governor. He listed off a laundry list of people that he sent that attorney-client privilege report to. So this was not a one-off.
Well, the city's interest in maintaining the confidentiality might be that the supplemental report could expose the city to liability. Is that sort of the interest that's sought to be protected here? That's
Certainly one of them. There's a myriad of interests that the city could be claiming privilege to protect. That's why city councils and bodies go out and have reports prepared by outside counsel to advise them on legal matters. Just because the public taxpayer dollars are being used to somehow pay for these reports doesn't necessarily mean they always make it into the public sphere because they're for legal advice.
Counsel, do you have anything for us on the attorney fee issue and rebuttal, or I think everything else has been well covered?
I think the only thing I would say is that the Van Elslander case says that while the actual attorney fee charge is not dispositive of the issue, it's error not to consider at least what the actual attorney fee being charged would be. And in this case, there was no consideration of that whatsoever. So with that, I have nothing further unless you have
Any other questions? All right. Thank you very much. Appreciate your arguments today. Thank you. That case is submitted. Item 9, the appeal was dismissed in item 9. Item 10 has already been argued. That takes us to item 11, docket number 374616, Dawn Marie Heaton versus Kevin David Heaton. Is Mr. Heaton in the courtroom? He's not, so that case will be submitted on the brief or briefs. Item 12, docket number 372803, In re R.S. Glover minor. Is Ms. Miller in the courtroom? No one's checked in. Item 12 will be submitted on the briefs. Item 13, consolidated cases. Docket numbers 373147 and 373165 in re Thompson minors. And we have petitioner appellee endorsed Ms. Schaub.
On behalf of people, Pierre County, on behalf of Ms. Shaw.
Okay. You are not endorsed for argument, correct? Okay, does anyone have, hang on. Does anyone have questions for appellant? Okay,
Not at this time.
I'll let you put your appearance on the record for us. No, you have to do it there.
Good afternoon. Ilanta Robbins appearing on behalf of Mrs. Thompson, the appellant in this matter.
All right, thank you for appearing. We don't have any questions for you. Now, counsel. Oh, all right.
Yes, Douglas Buck, P, number 36825 on behalf of appellant, the father and
That's right.
the minor children, Joseph Thompson.
Thank you, Mr. Buck. Good seeing you.
Good afternoon, Your Honors. Paul Walton on behalf of the Lapeer County Prosecutor's Office and Department of Human Services. We have thoroughly briefed the underlying issues in this case. It is a factually extensive record. I believe that Judge Scott made the appropriate decision in this case. There has been a prolonged history of the parents involved in this case, beginning back in 2017 when GT was originally born with controlled substances in her system. The Department of Human Services, along through the court system, had worked in a very extensive manner, attempting to reunify the children. It eventually culminated into a termination of parental rights on May of 2023 when GT was once again found to have controlled substances in her system. EMS had to be contacted. Narcan had to be administered twice. Through the court process, there was originally a jurisdictional issue that was pled to in this case, and originally the court had attempted to still move towards reunification, but because of the parents' response or their in response to the court's orders and requests for the parental parenting issues and continued controlled substance use, termination was eventually made. There was, as the court knows, there was a change of parties in this, change of attorneys in this case. And again, the court gave the parents' counsel, the opportunity to develop the record as necessary, to call witnesses as necessary. We believe that there has been no error committed in this case. Respectfully request that the court allow me to rely on the remainder of my argument for brief, unless the court has any questions.
Any questions for counsel? All right, seeing none. Thank you very much for
Thank you.
appearing, all of you. Appreciate it.
Thank you.
The case is submitted. And with that, we will be in recess until 10 o'clock tomorrow morning. Thank you.